Yes. Item number 4, my lord.
Just wait.
There has been a mistake. Wrong annexure 16, wrong document has been annexure 16. We are allowed to withdraw and file afresh.
Okay. Mr. Deepangi, learned counsel for the petitioner, Mr. Petitioner,
Petitioner.
he may be allowed to withdraw this petition with the liberty to file fresh. Praise the Lord. Representatives closed as withdrawn with the liberty as spread.
May I please, my lord?
Yes.
My lord, I beg to mention item number 22, my lord. My lord, yes, in this matter, I have to file one additional affidavit.
You
This-
are for
petitioner, my lord, yes.
Oh. On the
After
prayer
filing,
of
my lord-
Mr. N. Ramadan, counsel for the petition, list this matter after 2 weeks.
Yes, my lord.
Uh,
My lord, after 3 weeks, my lord. So I have to obtain some more documents, my lord.
After 3 weeks, so it's to
Additional.
enable him to file additional affidavit.
Yes, my lord.
MS R. Basar, London State Council is present.
Much of.
Lordship, I would like to mention item number 44, Your Lordship.
44.
Lordship, may kindly take up this matter on 16/6, Your Lordship. I've taken the consent of the petitioner, Your Lordship.
44.
44,
What's
last
the-
item.
Who is for
16,
the respondent?
Gyati, sir, Gyati, Xavier Gyati, Your Lordship. I've
Can I
taken the
take up this matter? This divisions, the writ appeal,
Yes, yes, Your Lordship.
I've authored a judgment of the writ appeal. Who is for the petitioner?
Xavier Gyati, Your Lordship.
All will dispose of what's there. There's nothing. We'll see. Who is appearing?
S. Tapin will appear, Your Lordship. He has some difficulty
You
with
go
it.
through the file, we'll see.
My lord, may I mention the content number 11/2025 to be listed tomorrow, my lord. I
Why?
want content number 11/2025 maybe list tomorrow, my lord. I want to withdraw the case.
Withdraw.
Yes, as
Hmm.
new cause of action has been raised.
Hmm?
New cause of action was raised.
For withdrawal, list it today also at 2. For withdrawal, will
Yes.
allow 2 at 2.
May I, Lordship? Lordship, I beg to mention item number 24.
Huh?
Item number 24, Lordship.
24.
Ah.
Yes.
Lordship, matter may adjourn for today.
Why?
We will file affidavit, Lordship. We will file affidavit, Lordship.
What affidavit?
Rejoinder affidavit, Lordship. For that, we need the two weeks time, Lordship.
On the prayer of Mr.
T. Tato.
Hmm?
T. Tato.
T.
Tato.
T.
Tato.
Tato.
Lordship.
For your name is not there.
Yes, Lordship.
Item 24.
Yes, Lordship.
You are for petitioner.
Yes, Lordship.
You are appearing for T. Tagum.
Yes, Lordship.
Mr. Swenso. No, on the prayer of Swenso. Appearing on behalf of Mr. T. Tagum, London Council for the petitioner. List this matter after 2 weeks for filing affidavit. in
Yes,
the-
Lordship.
Hmm.
Oblige,
You
Lordship.
record her name, Miss Swenso is present for state. Huh? Campus. There is no waste time for adjournment. What do you want?
Lordship, I want to mention an unlisted matter to be listed tomorrow for withdrawal.
Withdrawal today. 2 o'clock. 2 o'clock.
My lordship, I beg to mention item number 26 and 27. The conducting council is out of station and consent has been taken from the PP. And please fix the matter on 11th of June.
Yes. On the prayer of Swenso. List this matter after?
11th June. Fix the matter 11.
After a week. After a week.
Not in 13th of June.
Huh?
Not in 13th of June. 13th of June.
30.
1-3.
Why special day?
Because the conducting council might be,
Hmm?
he won't be available
Then back in next week?
after 2 weeks then.
Huh?
After 2 weeks then.
2 weeks, 2 weeks.
Lordship, I have to mention item number 3.
Hmm.
The council leading this matter is coming from out of station.
Hmm?
The council leading this matter is out of station. He comes.
Will
from-
issue notice? You have the brief?
No, no.
You have the brief. Give the second copy. Will issue notice? What's there? Read and make your submission. Two 2015
Madam.
election process. What's the reason behind?
Region, my lord.
What is the
my lord,
actual intention behind?
At this stage, my lord.
2015 selection process.
Yes, my lord.
So
At this stage, I am say very fair,
after
my
10
lord.
years, nearly 10 years.
At this, I say very fair, my lord. Intention is very fair, my lord.
Even he has completed his.
No, my lord.
Intention is unfair. Over.
No, I am very fair, my lord.
Why?
At this stage, my lord, I am saying.
Why?
Very genuine, my lord.
After 10 years,
Yes, my lord.
nearly 10 years.
This matter disclosed in the 2023, it's on the 2023.
Are you a graduate of which year?
No, my lord.
2019, your lordship.
You are
Yes, sir.
graduate of which year?
1919.
Say, then
My humble submission, my lord. I would say,
is
my,
it a PIL?
no, not PL, my lord.
Then you graduated in
My
2019.
lord.
You are you are challenging the selection process of 2015. Is it 15?
15, my lord, 15.
2015.
15.
Sir,
No, my lord, I would say, my lord, my qualification, my lord, my eligibility, my lord, will be not count from the vacant year, my lord. It should be from the recruitment, when the recruitment will be issued, my lord. From that only,
when it was completed, recruitment process.
not complete, my lord, since after 2000, that's why it's the 33
Started
posts,
in 2015.
33 posts were advertised, my lord.
Yes.
Thereafter, they were filled up, my lord. So, from 2016 to 18, until that, my lord, there has been from waiting list more than 146 appointed, my lord.
Till that, which is last appointment from the waiting list.
Last appointment would be, my lord, 2018, I say, now I have record 1817, 5, 2018, my lord.
Last.
Last, my lord.
You graduated in 19.
19, my lord.
Then, was your right?
No, my right would be,
It's not a PIL.
no, not a PL, my lord.
Then you graduated in 2019. The appointment was still up to 18,
No, my,
17 or 18.
my humble understanding.
Election process started in 2015.
No, my will kindly analyze this case in this way, my lord. It is not.
No, it's not the way what you want.
My-
They will decide the matter as per the law.
Yes, my lord. As far the law,
Not
my
what
lord.
you want to be.
Yes, my lord.
First of all, it's not a PIL.
Yes, my lord. I humbly submit it.
What right has been violated?
Yes, ma'am. I will try to explain it in two ways.
See, number one, you are graduated in the 2019.
19.
Wrongly or rightly, selection process started in 2015 and
15.
concluded whatever as per your allegation 2018.
18, my lord.
So, where do you stand?
Not concluded, my lord. They will give recruitment process was in the year 2015 only for 33 posts, my lord.
Yes.
That complete, my lord. That
Then
I have no locus, my lord. Locus, my lord. Now,
If you don't have locus, better it's there.
no,
Let
no,
the better, the person who has the locus, let them come.
no. I have two answers to that, my lord, query, my lord. My lord will see, my lord. Yes, for 33 posts, my lord. That complete in the 2015, my lord. I have no locus, my lord. After the base, the post vacant thereafter, my lord.
We are not issuing notice. We'll give you a time to argue on the maintainability.
I humbly, my lord, I'll try to satisfy my lord.
Heard Mr. El Perbe,
Today, my lord. I'll
that
try.
counsel for the petitioner. By filing this writ petition, the petitioner has challenged the selection process in the Department of Public Works, in the Public Works Department, Government of Arunachal Pradesh. What's the first, the advertisement?
Advertisement 24 to 2015, my lord.
Page 54,
80, my lord, page 80.
page 80.
My lord.
Starting, I don't know, what is it? Initiated by an advertisement dated 25/02/2015 for appointment of junior engineers.
Yes, my lord.
Within
33
bracket
posts.
civil bracket clause. And the consequential appointments starting from 2015, no, consequential appointment till 2018.
18, my lord.
Stuff. The allegation is to the effect that although the advertisement dated 25/05/2015, the allegation is to the effect that only 33 posts of junior engineers within bracket civil were advertised. However, by keeping wait list, another
I have now
33 plus
143, my lord.
143.
My lord.
That means total
176, my lord.
another 143
My lord.
persons posts have been filled up in violation of the settled position, in violation of the law. List of next paragraph. It is no. The petitioner admittedly is a graduate in
2009.
No,
civil,
in which-
civil engineering.
civil engineering
Bachelor of
in
Civil Engineering.
2019. By the time when the complete process of election, the selection, by the time the selection process has already been completed. This stuff. Then what is your submission?
My submission, my lord. The issue of locus, my lord, will be yes applicable up to the 33 post, my lord. Up to the 33 post, my lord, advantage 31. Thereafter, my lord, that
No,
other,
first you argue on the locus.
I am on the locus, my lord. Thereafter, my lord, that the post beyond 33, my lord, there was no advertisement,
Mr.
advertisement, my lord.
L.
Therefore, my lord,
Learned counsel for the petitioner while justifying the locus of the petitioner submits that although the petitioner is a graduate of 2019, however, since the the selection process, the said selection process is glaringly illegal in as much as the authorities have illegally filled up 143 posts over and above the 33 advertised posts, which is clearly in the teeth of the settled position of law. Please stop. Therefore, he submits that at the time, although at the time when the selection process was taken up, the petitioner may not have been eligible. However, the selection process itself is illegal. They may not be about to challenge at this stage also. At this stage, Mr. Next pair. Having considered the submissions of learned counsel for the petitioner, this court is of the considered prima facie view that the petitioner may not have a locus to challenge the selection process which has been undertaken before the petitioner was eligible. Please stop. However, considering the allegations about the learned counsel for the petitioner is granted 2 weeks time to argue on the locus as well as the delay and laches
My humble
in filing the writ petition. Mr. Mr. Swain's learned counsel for the petitioner. Learned state counsel enters appearance on behalf of the state. Next bearer. List this matter after 2 weeks.
My humble submission, day after tomorrow, my lord.
The issuance of the notice would subject to
Otherwise, my lord,
satisfactory.
even assuming my
subject to
the loc, this court find I have no locus, my lord.
subject
There is a settled
flexing of
principle of law by
good-
this
good
division bench
grounds
of
to approach this court. Approach this court after a delay, after approach this court. Ground on the delay as well as locus in approaching this court. You also prepare
Yes, sir.
list after 2 weeks.
my humble sir, day after tomorrow, my lord, will be better.
Maybe 1 week.
1 week.
You will not be able to satisfy. I am just giving you a
No, my
chance
lord,
because reason is very simple. There appears to be a glaring illegalities in appointing more than the post entities.
my lord.
Before that, once you cross the hurdles of locus and eligible, I mean the delay,
Assuming, my lord, I have
Well-
no locus, my
well,
lord. Then-
immediately,
assuming I have no
immediately.
locus, then also, my lord.
It's, that's why I'm saying I have indicated that's not a PL.
Yes,
Why
my-
not PL
Then
jurisdiction?
also, my lord, the
Thank you, sir. After, we'll meet after 1 week.
Oh, bless me. So bless.
I mean, we'll hear you, I'll hear you after 1 week.
May I please, my lord?
Yes.
My lord, in this writ petition, my lord, the petitioners are 2 in numbers, my lord, has assailed, my lord, cancellation of the land allotment by DC on 13/10/2022, my lord,
Yes.
cancelling the land allotment order dated 24,
Where it is, where the cancellation?
cancellation order also will find
Impute order,
at page, my lord, 182, my lord.
182.
Page 182, my lord. Operative part will be fine, lordship will find from page 189, my lord.
Hmm.
The land was initially allotted to the petitioners in the year 2004. Subsequently, my lord, my lord, eviction proceeding, my lord, Deputy Commissioner has, my lord, referred the matter to the government, my lord. And after verification by the government, my lord, by constituting a board, the board has recommended, my lord, for further modified allotment of the land to the petitioner. My lord, see page 189, para 15, my lord, kindly see the approval of the government for fresh allotment to the petitioner, para 415, my lord. On 23/7/2019, by letter number such and such, the Director of Land Management submitted a board was constituted and conducted physical verification on 27/2019, and accordingly, the government has approved the land allotment at A sector Naharlagan near office of the Superintendent Engineer Power in favor of, my lord, I am not representing, my lord, Kamkulamnio, Sanjay Dolo and Yamik Doke with terms and conditions. These are important, my lord. The terms, my lord, conditions for allotment, my lord. In the first instance, a proposal letter of the allotment may be issued to the person concerned to enable him to clear up the dues. After clearance of the dues and payment of the premium annual lease rent from the date of the occupation on the government land, the formal allotment order may be issued. Second condition, my lord. In case it is found, even in the later stage, that the land in question is within the distance from the central line of the road as notified by such and such, and proposed land is allotted to private individuals within the government quarters, buildings, premises, the land allotment shall be
So your, this allotment has been cancelled.
cancelled, my lord. My lord, by this cryptic order, my lord, in
When
contrary
you were
to,
appointed,
my lord,
I mean allotted,
my lord, 2019, my lord, the second modified allotment, my lord.
first initially,
First, 2004, my lord.
and second modified,
Order.
two allotment orders,
My lord,
two allotment orders.
no, that 2004 has been modified, my lord, in 2019, my lord, by reducing some part of the land, my lord. We are not agreed to the reduction of the area, my lord.
Finally, how much
From
area?
240 to 160 something, my lord, 69 square meter, my lord. And my lord, the terms of.
We'll see, we'll issue notice, what's the,
My lord, yes, ma'am, but we are seeking my stay of the, my lord.
what's the status quo?
Status quo, still we are in the position, my
We
lord.
don't know, we'll say status quo.
My lord,
You maintain status.
My lord,
I have a serious objection, my lord. My lord, before issuing interim, my lord, kindly hurt me, my lord, in this case.
No,
my lord.
that
This
in
is
that
the
even, my
content
lord,
for,
kindly, my lord,
This
allow
is the
me to
issue
complete,
where
my
my
lord.
lord, defender of the public property, my lord, try to take up the property, my lord.
Who? The
The
petitioner,
petitioner, my
they are
lord.
the defender of the
Yes,
state.
my lord. The public property, ultimately,
they
one petitioner is wife of the deputy director of the land management, my lord.
They become a Luther.
My lord. So
Huh?
my lord will kindly hurt me, my lord,
My
before
lord.
issuing interim, my lord.
My lord, for the, my lord, allotment of the land, either to private individuals or to the.
Anyway, we'll see. You file your affidavit, whatever is there.
But my
Or
lord,
Mr.
only say, my lord.
Learned counsel for the petitioner. How many petitioners?
Two petitioners, my lord.
What about the others? Is not
There are
interested.
three, my lord.
Yes.
Other is, my lord,
He is not,
he is not before.
he is not interested.
Maybe,
Ah.
my lord.
By filing this writ petition, the petitioners are aggrieved by, have put to challenge the order dated 13/10/2022. It's 2022.
And my lord, subsequently, my lord, went to appeal, my lord, pursuant to order of this honorable court, my lord. Whoever this honorable court has directed us to file appeal and to dispose of, and further direction to the secretary, my lord, to dispose of the appeal, my lord.
Where is that?
Honorable court's order, my lord, at page.
Passed by the Deputy Commissioner, Capital, Eternal Capital Complex, whereby the land allotment issued in favor of the petitioners, and one, who are the petitioners?
Sanjay Dolo and Yamik Doke.
Petitioners and one Sri Kamku Lamnio have been cancelled on the ground that the
My lord, we are
petitioner
representing, my lord.
and one
I'm sorry, my lord.
Sri Kamku Lamnio. The allotment of petitioners and Sri Kamku Lamnio
My lord, we are not
are
representing Lamia, my
in,
lord.
yes, are have been overlapped with the allotment order issued to the Department of Power at
A sector, no.
A
A
sector.
sector, no.
My lord,
Mahalali.
till date, my lord, no allotment has been issued to the power department, my lord.
No, my lord, in
That
the
was
2016, my lord, we
2017.
have issued land allotment.
17 the allotment to the petition, the department 2017.
Is the
Yours
approval-
is initially 2019.
19.
No,
approval
that
to
is
the-
what, where on the grounds of cancellation by the deputy commissioner.
Mine.
And what is the order of the secretary?
Secretary Lordship will find at page 227, my lord.
And also the order that is
Nine five 2025, my lord.
0905/2025 passed by the secretary to the government of Arunachal Pradesh Land Management. Where is this? Where is the last copy?
Page
234.
232, my lord. My lord, 233 and 4 are, my lord, not connected to this writ petition, my lord. It is wrongly, my lord.
Where is the
Next,
last?
last portion paragraph is, my lord, page 232, my lord. 231, therefore, 231, my lord. So it's a lower. Therefore, in view of above, the allotment made in favor of the Department of Power Government by approval dated
By which the appeal,
appeal, my lord.
appeal filed by the petitioner have been rejected by holding that the allotment made in favor of the Department of Power, Government of Arunachal Pradesh, dated 31/07/2016 stands valid and directed and hence the area allotted shall revert back to the Department of Power in its entirety. And also directed the Deputy Commissioner to initiate the proposal for cancellation of the allotment made in favor of the petitioner and one city, Kamkulam.
This time, my lord,
Issue notice returnable by 3 weeks. 3 weeks or 2 weeks? Since Mr. Who is for 1?
1, 2, and 3.
1, 2, and 3.
I am for 4, my lord.
Okay. For respondents.
Right.
Mr. As Mr. N. Long learned senior government advocate and Mr. L. Perme, learned standing counsel for department enters appearance on behalf of the we have already responded, no formal notice needed to be served. However, extra copies be furnished to the learned counsel for the learned state councils and the standing council. Next paragraph. Heard on next para, interim prayer. Next para. Having considered the submissions of land counsel for the petitioner and also on perusal of the documents annexed to the writ petition. And also considering that the allotment of the petitioners was made in the year 2004. And thereafter, after the series of proceedings, the land the allotment of land has been reduced to certain area and finally allotted in 2019. And the allotment allotment in favor of the power department stated to be approved in the year 2017,
16, Madam.
till the returnable debt status quo in respect of the land in question, lands in question be maintained by the parties.
Okay. Okay.
Yes.
Lordship, this is a pensionary matter
Yes.
wherein the petitioner herein has reached superannuation on 31/10 of 2022.
You're working as a
WC assistant mason at PWT.
regularized
Yes.
WC assistant mason. You are entitled for pension.
Yes.
Pension.
Yes, Lordship.
Yes, sir.
This only notice for this.
Why notice? It's a pension. Is he not entitled?
But there is some excess payment that has been made
Where?
to the petitioner.
It's for recovery, against the recovery. What is your prayer? What do you want?
Lordship, there are series of orders and notice
Saying what?
passed by that the petitioner herein has been paid in extra during his.
Yes,
time of
law is
service.
very clear. You cannot recover 4th grade after the retirement. Rafiq Basi. Sir, how do you heard? Have you gone through? Have you read the judgment? You could have. There is a judgment of this court also, based on Rafiq Basi, and thereafter, money judgment. Heard Mr. So-and-so, learned counsel for the petitioner. By filing this writ petition, petitioner, no, just cut it. Challenge made in his writ petition is to the order dated 16/08/2024, issued by the, passed by the, where it is? Where it is?
Passed by the executive engineer.
Where it is? Passed by the executive engineer, page 56, Jarampur Division, PWD. By which an excess amount of rupees 12 lakhs ₹3,830 is sought to be recovered. Being excess amount drawn by the petitioner issue notice returnable by 3 weeks. Next para, Mr. N. Long, Leonard Senior Government. Since Mr. N. Long, Leonard Senior Government Advocate appears on behalf of all the respond. Are you appearing for all?
5, 6, and 7.
Huh?
Oh,
Who is for PWD?
yes,
All the respondents. No formal notice, no, the formal notice is waived. Issuance of no formal notice is waived, huh? Next, Mr. Over excessively punished to the land council. You expect punishment. Considering next para, that the petitioner has retired as WPC, WC, what?
Assistant Master.
WC Assistant Mason, which is fourth grade employee, fourth grade post, comma, till the returnable that no recovery shall be made pursuant to the impure order. That is so and so 1610, 16/8/2024. Sorry.
Lordship, this matter is case of the merger, Lordship. Case of the merger, Lordship.
Yes.
Lordship, petitioner is office superintendent, senior most cadre in his department, Lordship. And annexure 2 is list.
Are you challenging the seniority list?
Yes,
Yes. Where it is?
Your Honor.
Final seniority list. Is it final?
Yes,
Is it the final senior? You are a gradation list.
Your Honor.
You are challenging the seniority list.
Yes, Lord.
Where it is?
Lordship, page number 55, Lordship.
55.
Yes. Lordship, this private respondent.
It's all right. 55. This final.
Yes, Lordship. Annexure number.
Challenge made heard Mr. G. Kato, petitioner. Mr. No, challenge made in this writ petition is to the final intercity seniority list of office superintendent of director of food and civil supply, government of Arunachal Pradesh, issued by the under secretary within bracket FNCS bracket close, government of Arunachal Pradesh. Yes, what do you want to say?
Lordship,
Where's your name? You are serial number 5.
yes, Lordship.
You are claiming seniority over?
Yes, Lordship. They are
Seniority over whom?
Lordship, seniority over me, Lordship. Lordship, they are actually from the
Forget about that. Which is you are claiming seniority over whom?
Lordship.
All of them.
Yes. 1, 2, 4.
1 to 4.
Yes, Lordship. Because they are merger. They are merger into my department.
Yes.
Lordship, on that account, for the seniority list, they have to be they have to be, their seniority period has to be count from the when they merge after shrinking of their department, Lordship. It is my, that DST department, this has been in that, Lordship, winding up, Lordship.
You were in originally
Lordship,
in this department.
Lordship, I am DFCS, Lordship.
They merged from
They are from the DST, Lordship.
GST.
Yes.
Observe on which date?
Lordship, they Lordship, private respondent.
See, date of first entry into service, date of appointment to the present post, right?
Lordship.
That is superintendent, huh?
Yes, Lordship.
Right?
Office superintendent.
Your appointment is 0109/24/04. So how can you be senior?
Now, Lordship, that since they are merger into my department,
It
Lordship,
is contended by Mr. G. Kato that the Respondents, all private respondents.
Yes, Lordship.
Number,
Number, Lordship, 1 to 4, Lordship.
are yaar, in your petition, who is the respondent? Respondent
4
number?
to 7, Lordship.
Huh?
4 to 7 is private
Yes.
respondent.
Respondent number 4 to 7. Who merged from the Artswell, what is that department?
DST, Director of
Department.
Supply and Transport.
Director of Supply and Transport into the Director of Food and Civil Supplies. In the year
In the year 2017, Lordship.
2017, their services ought to have been considered from the date of merger and not from the date of their initial appointment in their earlier departments.
Lordship.
Please stop. Since the petitioner has been working, appointed as superintendent on 01/09/2004, and the respondents, private respondents having been merged in the year 2017.
Yes, Lordship.
17.
17.
2017. 17. The petitioner ought to be placed above the respondent, private respondents. But that cannot be.
Lordship, here is one observation by Supreme Court.
It's not a case of deputation or something like that.
Lordship, this is
Issue notice returnable by 4 weeks. As MS R. Basar, London State Council appears, enters appearance and accepts notice on behalf of all the respondents, no formal notice. For a respondent 1 to 3. No formal notice need be issued. However, extra copies. Land counsel for the petitioners to take steps for service of notice after respondent 4 to 7, were registered for services.
Lordship, my humble submission, if it is not staged for the interim, Lordship.
I'm not convinced. How can you deprive the people? It's
Lordship,
not a
yes.
case of, it's not their fault. They have not come of their own choice. It has been, department has been merged, same post.
No, Lordship, there are some circumstances that this is not.
That's why we have issued, we'll see.
Lordship.
But otherwise, privacy, you cannot deprive.
Lordship, one Supreme Court has clearly stated that in case of promotion, they should be, their service should be counted from the when they enter into the new post, new department, Lordship.
In which, in the case of merger also,
Lordship,
in the case of merger,
case of
in the department merger, if the other departments merge into another department, is there no choice? They were helpless. There was no option
and Lordship,
other than to go into the merged department.
Lordship, this is not why this is not case of marriage. Is some of the most of the employee they then merge into the civil aviation and the director of personnel. So this cannot be treated as the amalgamation of the two companies, two department, Lordship, because some this transfer into the civil aviation and some into the personnel department of personnel and treasurer account, Lordship.
We'll see. We'll see.
Lordship.
We'll see. We'll see. After 4 weeks.
All right, Lordship.
Dismissed.
May I pray that, Malad,
Again, Nagendra, what is that? Nagendra Chandra,
Malad, admittedly, Malad. However, Malad,
State of Jharkhand,
Malad, may,
2008, 1 SCC 798. What do you
may I
want?
pray that I may be allowed to, Malad, file the rejoinder to at least establish my case, Malad.
What is that thing?
After 3 weeks, Malad. I'll come with my rejoinder.
Why don't you make it for 6 weeks? Huh?
3 weeks, Malad.
You go through that, Nagendra.
Yes, ma'am. Malad, otherwise, Malad, it is well settled position, Malad. termination has been done.
I told,
But what we are praying for is, my lord, at least before termination order, one opportunity.
it is
at
not
least.
required.
That is the only, my lord.
That is the law. That is not required. You have been given,
True.
so-called notice was issued.
My lord, my
It's more than enough.
At least,
Admittedly, there is no advertisement, there is no selection process.
true, man. That part we are admitting, man. Only thing is that, my lord, before giving, my
Not
lord,
to talk about violation of the rule. All right.
I'll come with the additional affidavit.
Why don't you club all these cases together?
My lord.
Yeah, how many cases are there?
Some of the cases, my lord, we are the club, my lord. This is where,
How many cases are there?
my lord, altogether
Out of same appointment and out of same the termination order.
my lord, around 40 is there, my lord.
Club
We-
it
we'll club-
together.
Some of we have already.
We'll
clubbed.
hear it, dispose it of.
My lord,
My
it will be difficult for the.
Things
other
has to be
petitioner.
changed. Forget about this.
My
Look, look for a better, I mean.
Yes,
thing.
ma'am.
What is your age?
Now, my lord, we are.
What is your age?
Even, my lord, age is already expired, my lord.
No, in Nagendra, it has
In
been.
other cases also, my lord, the age. age
Nagendra, the Supreme Court has provided to relax the age. That can be done. In certain circumstances.
Certain.
Of course, while the court will not relax, we may direct them to consider relaxation
Yes, ma'am.
if law, I mean, rules permits.
My lord.
Deeply aware.
Just because you want to file reply,
Well,
although I don't see, I mean, this court doesn't see anything you can improve by your
Sure.
reply. It's a
at least,
open and shut case.
at least we are trying to find out the way out where the, my lord, at least some.
How to convince the authority. Better go and convince them.
My lord.
But it has been blown.
Yes,
I mean, it's all in the public domain.
sure.
What if the criminal case?
My lord,
It
it's
is
going
pen-
on.
it's still pending, man.
You are also accused. Are you also accused?
No, man. That is the irony of the case, my lord. The one, my lord, the two files are missing from the department. And without, my lord, having that files, my lord, the conclusion has been drawn that no appointment order has been issued from the so and so office. So where from they are, my lord, making.
That
such
is more
statement?
serious. That's why they've been booked.
My lord, as of now, my lord, none of the investigation authority has found out the, my lord, the.
What is the
The vision
stage of
file.
that investigation?
Investigation, my lord,
Case,
SIT is dealing, my lord, altogether.
charge sheet has been filed.
My lord, some of them charge sheet has already been filed and other my lord, investigation going on, my lord.
My lord, deep.
On the prayer of Mr. M. Kato, learned counsel for the petitioner, this matter, after 3 weeks,
My lord.
so as to enable him to file affidavit in
Deep.
reply. Mr. Sojo, Tita, Standing Counsel for
Yes,
Education
education.
Department has no objection. This after 3 weeks.
Deeply aware.
Yes.
May I flag names? But in this matter, my lord,
What is the
one,
affidavit? Affidavit has been filed.
They have filed the affidavit.
Huh?
In one matter, things are completed.
Yeah.
Your lordship, this morning I received a phone call.
may I please, your lordship?
Your lordship.
May I
Huh.
please, your
He
lordship?
had, Since he is not feeling well, he is unable.
Is there for the
May I
petitioner?
please, your lordship? I'm appearing on behalf of DK Devresa, your lordship. Your lordship, he requested me to take adjournment
Why?
of this matter, your lordship. He informed me that he could not appear due to some medical reason, your lordship.
You are for petitioner.
Yes, your lordship.
In some of the, on DK Devi's case.
Item
or-
number 7 to 18, your lordship.
Hmm.
7 to 18, your lordship.
On behalf of DK,
Yes, your lordship.
Mr. Mo,
I'm appearing for 18.
18.
Oh, sorry, 19.
19 is what?
Same matter, lordship, same matter.
Why this has been?
Analogous matter.
Yeah. What is the case? Your case?
My case is also basically it's a ejection order.
What's
issued.
wrong there? What is the wrong? It's a forest land.
No, it's a village. Basically, it's a notified village.
So as the documents. It's a
Forest
notified
Department
village.
affidavit says this is an
Just
encroachment of a forest land.
Just wait. So as the notified,
We have filed the rejoinder today.
No, show all the documents where it has been declared as village and recognized and has it been published? Gazetted?
Yes, yes, it is published in the
Item
Gazette.
18.
Sir.
18. Item 18.
19.
19. This is up to 7 to 9. 7 to 19. Yeah. 18. 18. Eighteen. 18, yes.
Yes.
Page.
I'll just take to the notifications. I'll just take the notification.
Yes. Sir, your matter is 19.
Mine is 19.
Yes. Yes, please.
Yes, yes, I'm just taking to that. Notification is there. Page 38 and 39. And 39.
39.
Yes. 39, I think this is notification.
What is 39?
Yes, 39. May I just take to the notification, the last, there is a notification in the,
It's some appointment order.
no, next one, 39, next one. There's two notification,
39.
39.
Why you have given this? Anantalal Chakma. Huh? Anantalal Chakma, yes. Yes. Why the supplementary input here? Yes, page 39.
Yes, 39.
What does it say?
39, may I just read notification, it's written 31st August 2006. So I will just take to the, it says, may I read that one? In the interest of the public service, Governor of Arunachal Pradesh is pleased to accord
Following
approval.
villages is recommended by respective deputy commissioner.
Yeah, renaming of the following town villages as recommended by the respective deputy commissioner.
Tanglang
In the
district.
third A.
Modakka Nala.
Modokka Nala as a Modokrong. It has been renamed as a Modokrong. Modokka Nala, Modokrong. So this, the area which they wants to bring the project, especially exploration, it comes under this village area. I say it's a notified area.
But then before that, it is a notified reserve forest.
Before
Does it?
The area that they are showing is not the area concerned. The forest department has filed their affidavit. They have said the land in question is Doyum Reserve Forest. What they are trying to do is show the recognized village area. And by showing that, they are trying to present the case that this is a village area. But we are not concerned with the village area. What is under encroachment is a Doyum Reserve Forest area, and the forest department's affidavit is clear on that.
They are not settling over there.
No,
They
this
are not settling over there. Maybe for agricultural purpose and other things.
yes.
they are
So this
dedicated.
area where we want to explore is under the Doyum Forest Reserve and is not under the recognized village.
Is it permissible for you also?
We have a PML license for this, Lordship. The license
Can it be done within the reserve forest?
with the reserve forest. Yes, if the forest clearance, is there, everything has been given
Is
to us
there
by the
any
ministry.
clearance? Is there any clearance? Forest clearance?
Everything is there. That is why we are now
No,
having the
once
deed.
it is reserve forest, it's not the department who will issue a clearance. It
No,
has
it
to be
comes
by
from the
central
ministry. It comes from the
yeah.
ministry.
It has come.
Everything is there
You
with
have
us.
filed affidavit.
We have filed our affidavit, but this-
Have they said all this thing? That the forest clearance and all this thing from the ministry?
in our affidavit, we have said,
Hmm.
after all the formalities have been done, at the ministry's level, this is not done here, in the local level. It's
That's
done at
why-
ministry's
But
level.
then it should be with them, no?
Lordship?
If they clearance from the ministry,
Yes, Lordship.
environment forest, it has to be central government, has to go to them also. They should have the
Yes,
document.
it has gone through them. And now, in fact,
That's why what they are saying.
they are
so-
saying that everything is done. All the formalities is required to be done.
Have they annexed all those documents?
That is not the subject matter of this writ petition.
No,
today.
no.
Subject matter
Oh,
was
no, would like to go beyond that.
that.
Suppose
then-
if you say that they cannot claim over the reserve forest, for example,
Yes, Lordship.
you equally don't have the
Then
right to,
that is a different aspect altogether.
that will consider it. Will not just go by what he has said.
His case is that I am up
Why you have been singled out?
That's why
What is
now
the reason?
reason they have not provided.
Hmm?
Reason they have not provided. Kindly come to page 105. Just brief background 105.
Yes.
This is the letter, my lord, written by the general and April. And time. His age was 38 years, 8 months, 14 days. Subsequently, his service as conductor was regularized with retrospective effect by order number so and so, so and so. Hence, it is requested to condemn the age of Sri Tanya Thakur, retired conductor, by 5 years in order to finalize his pension case. The service book of said retired conductor along with relevant document as shown in Annexure A is enclosed here. This I have obtained through RTI, my lord.
There was a clarification also. Then what had happened? Nothing.
Nothing happened.
Radhika Mohan
Clarification is
Sekia.
at page 109, my lord.
Yes, 1111. Somebody, Mr. Sekia was,
My lord, similarly
Yes.
situated case.
yes, what is your stand? Who has to condone it?
Yes, Your Worship.
Who has to condone the age?
General Manager, Your Worship.
No, unless the government does it. General manager is writing, keep writing. Please
Yes.
condone.
It has to be done by the government,
Which the government department?
transport department.
Transport department, commissioner,
My lord.
not the general manager.
And as on that, my
Yes,
lord,
who has filed this? Anybody filed
affidavit,
an affidavit?
affidavit filed by
Filed
respondent
by-
number 5.
Yes, fine.
Commissioner.
No,
Audit and pension.
audit.
No, whatever
They are
the
they are
commissioner.
supporting my case. Commissioner has not yet filed.
Huh?
Commissioner has not yet
Who
filed.
is appearing for commissioner?
I am appearing, Your Worship.
So,
We will
no,
file-
this director is saying what? Audit and pension. You are saying that the respondent 5 is in your favor
in my favor, saying that
unless it is condoned.
unless it is condemned, and
That's
then
what I'm saying. It has to be condoned first. Otherwise, you will not get it.
and then they have annexed to document which we are also relying, as per some notification of the government. The pension paper.
That's
said-
why the important, the commissioner has to file an affidavit.
Yes, Your Worship.
Well, I mean, making their stand clear.
Right.
You take note of it and file an affidavit. We're not concerned, we're not interested in respondent number 5. Although you may file it, because since you are supporting his case,
Yes.
in fact, he's also not supporting. He said, unless the age is
Right.
condoned, how can we pass the thing? I mean, for pensionary and other thing.
Right.
This is what is shifting the burden.
And in
Your
this
Worship,
case, my
2
lord,
weeks, Your
as per notification, pension paper has to be get ready before the incumbent retired, 4 months before the incumbent retires. But in this case,
So what is to be done?
Your Worship will take
Should we direct
instruction.
you to condone the age and
Your Worship may kindly grant us 2 weeks time. We'll take the instruction.
not Mr. K. Tamalan, counsel for the petitioner. and MS.
Last order also, my lord, pending sin, endeavor has to be made to dispose of.
P. Sangita, huh? Yes, last order 12/3/2025,
My lord,
1 week. You take for state responders, huh? P. Sangita, huh? Considering that the present petition, this is present matter pertains to payment of pension and other retired benefits. In respect of the petitioner who had retired from
31.
service on 31
August 2022.
08/2022. And also considering the order passed by this court on 12/03/2025, a weeks, huh? Week as happens to this. Time is granted to the state respondents to file affidavit and to obtain instruction and file affidavit as a last chance. Last chance, we didn't want it. List
Your Lord-
matter after
2
as
weeks,
is spread for list matter after 2 weeks. On which date it is made clear that on the next date endeavor shall be made to dispose of the matter.
Obliged.
My lord, this is a subsequent bail application, my lord. The earlier one was rejected on February last, my lord, on the ground that the victim was not examined. But now, my lord, the victim is already examined and the accused is in the jail for the last 11 months and 24 days now, my lord. So, and there are as many as 7 witnesses, prosecution witnesses to be examined, which may prolong, my lord.
Why it should be prolonged? Unless you prolong, what is the last rejection?
Last rejection, my lord, is page 113 onward. The operative portion is from page 114, my. Because the victim was not examined then.
How many witnesses have been examined by now?
Only the victim, my lord, but 5 prosecution witnesses are to be examined. So, and my lord, the accused, health of the accused is also, my lord, deteriorating in the jail day by day, my. Although we have not annexed any medical documents, my lord. Although he is a non-APST, my lord, he is born and brought up here and is residing at Polo Colony in Naharlagan.
Now, only the victim.
Yes, ma'am.
Lordship, Lordship, aware of the X versus state of Horizon, Lordship.
Huh?
X versus state of Horizon, Lordship.
What?
X versus state
Ah.
of Horizon, Lordship,
Yes.
wherein Honorable Supreme Court opined it once the trial is commenced, Lordship.
That is, we have relied earlier
Yes, Lordship.
and rejected the
And,
bail.
moreover, victim was also not represented by Lordship, any counsel.
But how long you should put him behind the 11 months?
Yes, Lordship.
Why he should not be granted bail? 11 months.
Yes, his trial is commenced, Lordship. The best court will be the trial court, Lordship, to grant the bail, Lordship.
Have you approached the trial court?
Earlier we approached, my lord, but it rejected.
After the rejection of this,
No, ma'am. Prior to filing of application in this court, ma'am.
then you go to trial court. Because examination is going on. I mean, trial has started, as I already comments. Prosecution witness service has already been started.
My
We
lord,
approached it.
no, my lord, although the
Because
trial
this is the best, trial court would be the best court to know.
although the
Why,
trial-
why the accused should be in custody? There's no other ground
my lord,
except the 11 months.
he is not yet convicted, my lord, and he should not be kept in custody for indefinite period at least, my lord.
But Supreme Court says in the serious matter like rape and POCSO matter, once the trial commences, unless you can show that the trial may prolong, it's a 7 witnesses only. The London PP has no objection. Mr. Having considering the submissions above, let this matter be posted after 2 weeks, posted to 2 weeks. Posted after 2 weeks. 2 days. Sorry. You also think about it.
Yes.
11 months. Why he should be kept continuously in consideration? On after posted after 2 days. On when?
11.
Eh,
11, ma'am.
11. 11.
Okay.
There is a change of circumstances against you. Last order, have you seen? Supreme Court is heavy on us.
No, my lord,
In other case,
yes,
and the trial has been
shifted to
shifted.
Guwahati, yes, madam.
Why don't we approach the court below,
My lord,
court, trial court at Guwahati?
Madam, that time when we filed bail application, my lord, it was in May, lordship, 22nd, on 6th May.
Yes,
That's more
thereafter the judgment.
More
is there.
than, no, my lord, that judgment was there, my lord.
No, this was after that. I'll tell you.
No, my
I'll
lord,
show you.
that
This is on
I give a
First-
copy, Malad,
first place.
placed a copy.
Huh?
It was
First
before
May.
that, Malad. Order was.
Okay, 1st of May.
Yes, Malad. I placed a copy of that order, Malad.
This bail application is a regular bail or what?
Yes. Malad, what happened, Lordship and
I think in
kindly.
view of this, you have to approach.
Malad, sir, this is, we are not on the merit
have
of the
read
case, merit of the case as such, Malad.
Whatever. It's very difficult. You have read it, you have placed it
Yes, I placed.
in Kazam Dada, Yana Rangmo and
Yes.
others. It's an indication. I have read it. Yes, what is the health status?
There is nothing, see, the lordship just stated that the case was submitted and submitted for the.
No, last time we direct you to obtain the instruction. To obtain the health condition of the accused.
This is still, Malad, this just recently.
Have
been
you
over.
gone, have you read it?
Yes, yes,
Entire,
yes,
entire.
yes.
It's an indication, there's an indication. It's not only about the others, about the accused who has been granted. So it includes everyone, else accused. So I was reading yesterday.
Yes,
That day I did, to be frank, I didn't have a time to go through. I read it last time. It's an indication. But there's no, I mean, bar that you cannot approach the trial court. It's clearly given.
No, Malad, what happened?
It should
Malad?
not be influenced by the order, but then the bail which the court has and the magistrate has granted, it has been deprecated.
The circumstances under which my lordship we approached, my lordship may kindly appreciate. At that time, he was.
Have you been shifted?
No, my lord, what happened?
See, respondent shall be at liberty to apply for regular at an appropriate stage, and such an application shall be considered trial court or the high court as the case may be, as per its own merit, without being influenced by the observation made here. It's an indication before that there are certain
I
observations.
appreciate lordship.
So the trial court will not influence by that, right?
Yes.
So I
Kindly see Annexure 9 page, how, under what circumstances we approach this court, Malad. It's totally different, man. At that point of time, the present applicant was not even charge sheeted, man.
Huh?
When we filed the application.
Now he has been.
Now he has been.
He has been shifted to. Has he been shifted?
No, he's in medical manner. Therefore,
I mean, in on paper he's shifted.
yes.
So that's the same reason. I know. There is the jail superintendent. Apollo Excellence. This from
22.
Apollo.
Yes. More serious health condition, man. He was already operated for this liver cancer, man.
No, I understand. That's it. There's no other ground to grant you bail
Yes.
except all medical
Yes.
reason. But problem is that at that point of time when you approach this,
Yes.
there was no charge sheet. Number one.
Yes.
Number two, you have not been shifted.
Malad,
You are deemed to be shifted. Since you are in the hospital, physically you cannot
yeah.
be.
At that point of time, Malad, that's why I mean, the page
Because those,
48,
at that
they-
point of time, these two
jail
people-
jail authority refused to keep me in the judicial custody because I was not fit to be
That's
kept.
why you are already out practically. You are
Yes.
not in the jail.
Yes.
So you have to approach, taking into consideration of this. Because it would not be proper when they have made an observation, all the accused persons in, of course, in a different proceedings, other proceedings out of the same case.
The
You,
observation.
you try to understand also.
Yes. There was no bar, my lord, to approach High Court.
There's
or-
no bar, but the problem is you have to approach. We granted, not we, the High Court or the trial court, at one point of time, we granted some of the accused. But then Supreme Court is heavy on it now.
Pertaining to only-
And I'm sure that is the only difficulty. Otherwise, the medical ground to, there's no dispute. We'll allow you to approach. Go and approach there.
More than a month, my lord, this application was pending, my lord. That's why the problem, my lord.
What can we do? You have seen this.
Yes. The circumstances was totally different at that point of time, man. Because the custody, they could not keep him, man. Therefore, we had, and no, there was no session judge at SEPA at that point of time.
Where is now presently?
Now it's the Apollo Care.
Guwahati.
Yes, he have just on 22nd, he was operated second time. 22nd May.
Yes.
Your Lordship, I'm appearing on behalf of A. Tiwari and he's appearing through VC.
Who?
A. Tiwari.
Complainant, my lord. I am for the complainant in this, my lord. I was the counsel before the Supreme Court as well. I would request, my lords, to get a proper medical report from the Guwahati hospital, because even in the other case, my lords, the Itanagar hospital's report.
No, you see, Mr. Counsel.
Yes, my lord.
On 20/05/2025, you are there. We have directed the learned PP to obtain the health condition of the accused.
Yes, my
right.
lord. Yes, my lord.
And they have furnished a letter which is addressed to the jail superintendent, SEPA.
Yes, my lord.
By the doctor from the Apollo Excel Care Hospital, Guwahati.
Yes,
Have
ma'am.
given the detailed ailments and the surgery, everything. So can we just ignore this?
Not at all, my lord. If
And
they,
in earlier proceedings also, the Supreme Court has, although in the facts of during this circumstances has heavy on it, but then the direction is to approach if to the before the trial court, and if it's approached, it will not be influenced by the observation made therein, right?
yes, yes, ma'am. Of course, of course.
So we'll have to balance the both the, I mean, the right and liberty of the accused as well as the
course,
interest of trial also.
My only submission is the Supreme Court has requested the trial court to finish the trial in 1 year. The individual is already in hospital. It's not that he's in court. Let the private witnesses happen, my lords. My only submission.
Yes.
Let the private witnesses happen. This is a case, my lords, where it is on record that some of the co-accused have tried to influence the private witnesses. The PP will agree with me. This is on record. So let the private witnesses happen. This particular petitioner is already in the hospital, my lords. He will not be shifted even within
So
custody.
so you don't have a objection as such
No, my lord,
because of the health ground.
Of course, my lord. How can I object on health, my lord? I as a counsel, I'm an officer of the court. My request would be that let the
So that's
private.
why I'm saying the apprehension is that there's a threat to the witnesses, is likely, I mean, allegation of threat.
Yes, my lord.
Since he's already in a serious condition, having a surgery in the hospital, I think we'll have to put some condition which the learned people would like to,
I will leave- I will
make
leave
it,
it-
or you may suggest also, we'll put some condition, because we
Yes.
cannot just ignore the health condition. It appears to be very serious.
My lord, my suggestion would be let him be out on interim bail for 3 months. And in the meantime, my lords, the Honorable Supreme Court has asked the Honorable Guwahati High Court to monitor the trial. In 3 months, I am very certain that at least the private witnesses would be examined. That I think would be better, my lords. Interim bail, obviously, my lords can consider. And we can relook at how the trial has progressed after 3 months, my lords. He is already in the hospital. He's not in the jail, my lords. As per prison rules, unless he is fit, he has to be in the hospital only.
Interim bail, would it be appropriate? Yes.
My lord, this honorable court can, my lord. Because totally health condition, my lord, they don't want to keep him in a prison, my lord. That's the problem. And he's unfit to be kept. That's the main thing.
Okay. I'll pass the order.
Obliged.
So I'll record your submission.
Yes,
That you have fairly submitted so and so,
Yes.
right?
Yes.
What you have submitted.
Yes.
And on the basis of the report of the doctor,
Yes.
we'll grant them in that case 3 months interim bail
Yes.
for 3 months.
Obliged.
Obliged.
We'll pass the order, huh, Chamber. All right.
Obliged.
Any other? Any condition you would like to be put in?
There's no,
Impose.
no allegation against him, my lord, for doing anything.
No, that we were not now.
He was bedridden right from the beginning, man.
Don't put pressure on us.
No, obliged.
Heard Mr. Peter for learned counsel for the petitioner and PP, this Deloy PP and Mr. Abhimanyu A. Tiwari. Learned counsel appearing for complainant. But you are not a party.
No, my lord. I am for the complainant, my lord, of course. In bail, I have not been made an official party.
Okay.
May I plead, Your Lordship?
Yes.
Well, this matter, this is a contempt matter, my lord. In this matter, my lord, as per the direction of 10/3/2023,
Yes.
this matter is related to the payment of solution. Deputy Director, Contempt number 1, Deputy Commissioner, he was directed to verify and pay the compensation. So in this matter, Deputy Commissioner has verified.
Page.
Page is operative process, page 28. Let me read. I have read the judgment and order, judgment rendered by the division bench of this court dated 12/9/2022 in Rate April 15, 2022, wherein it has been held that through the petition land therein were acquired under section 10 of the Act of 1947, yet the petitioner are entitled.
What happened? What happened thereafter?
Yes, after that, Your Lordship, I will just take to the relevant paragraph is 64,
Lordship.
page
I
64.
have a prayer, Your Lordship. Yeah. I'm appearing on behalf of Estapin, Your Lordship. He's representing respondent number 1, Your Lordship. May I kindly take up this matter tomorrow, Your Lordship? He is not present today.
Is it
He has some
complaint, sir?
difficulty.
Has it been complained or not?
Basically, the Deputy Commissioner has verified and sent to the director.
Yes.
But then contempt number 2,
Secretary,
secretary has
I'm
filed
appearing on behalf
affidavit.
of respondent number 2.
Yes.
Affidavit and saying that.
DC has done his part.
Yes,
Then-
but
Your Lordship, we have preferred an SLP.
now,
against
now he is saying that we cannot comply because there is a SLP pending in the Supreme Court. That is his statement in the affidavit.
No, Your Lordship, I beg to mention that we also have an stay order against the impugned judgment order dated 12/9/2022.
There is a stay.
Yes,
Yes.
Lordship.
Yes, that is
We are
the.
closing it. No contempt. Hard Mr.
My lord,
Huh?
stay is there, but then no, they have not yet.
So if the basis is of that matter only, division bench, that has been stayed.
So, but then-
Otherwise also, it's not a willful disobedience.
No, my lord, Deputy Commissioner has to verify and send to the director.
Send it.
Yes.
Okay. In the meantime, the basis of this direction is division
but-
bench order.
But then,
That has been stayed.
but then there one more contempt. Now, this is a BRTF.
Huh?
BRTF,
What BRT?
the Border Road Organization.
Yes.
So once the money is verified and sent to the BRTF, then only BRTF will deposit the amount.
So,
So if, even if it is pending in the Supreme Court, once if it stays, if disposed in our favor, then the concerned authority has to act upon that.
It has not been disposed of.
No, that is not disposed of. Read
The order of the division bench of this
Yes.
court has been stayed. That was the basis for a direction to do all this
Yes,
exercise.
yes.
So
But the matter
there
is
is no
pending,
contempt.
but the matter is pending in the Supreme Court. Once the,
So there is a stay on the order of the division bench.
but then once the stay is lifted, we are hoping that the stay,
Then you will come back.
then my lord, the second contempt will not come into play. So
There is no contempt. All right.
no, thing is that it has to be paid.
Much less willful. There is no contempt.
My lord, once the money has to be verified and it has to be sent to the BRTF, and BRTF has to deposit the money.
Yes, the moment, it's not a question of this thing. Once the moment the Supreme Court decides the matter to your entitlement.
Yes. But then,
Matter ends there.
but then
It was
again,
a question of why you are thinking of the contempt. You are thinking of your relief, which you are seeking.
so my lord,
Are you interested in your money or are you interested to furnish the officer?
no, I'm not, so I will
Then
just,
why you are thinking about the next second contempt, third contempt?
no, my lord, I will just pray
We'll
that,
have to see whether there is a violation or not. Not only violation, there is whether there is a willful disobedience.
so now,
If it is not willful, there is no contempt.
so my lord, I will pray that,
I will exercise the contempt.
my lord, I will pray that till disposal of that, it may be kept abeyance till the disposal of the Supreme Court judgment, Supreme Court orders, you know, sir. Till abeyance, yours.
Then in that case, on the prayer of Mr. S. Mo, learned counsel for the petitioner. And no, Mr. S. Mo, learned counsel for the petitioner submits that the regarding payment of
Salvation, my lord.
compensation with solicitor. And the method regarding payment of compensation with solution is pending before the Supreme Court. And the judgment and order of the division bench dated 12/09/2022 in WA 15/2022 has been stayed by the Honorable Supreme Court. Mr. B ordered dated 0/10/03/2023 passed by this court, for which the present contempt petition has been filed. And the basis of such direction by the above order of this court is the writ appeal, judgment order dated 12/09/2022 in the aforesaid writ appeal. Please stop. He submits that in view of the pendency of the matter before the Honorable Supreme Court, matter may be posted after 6 months. 6 months.
After
3 months.
Your Lordship, I'd like to mention that this
Mr.
contempt case, this may be
Swain,
disposed of.
counsel for the- Huh?
I'd like to request that this contempt case may be disposed of because there is no willful disobedience on the part of the contemner. Because
We'll see after 3 months.
I'm like,
All right. Mr. So-and-so, learn counsel for the, you are for one. MS Arbasar, learn counsel for Alice Contemner 1 and Mr. So-and-so are present.
obliged.
30. 30. Yes.
Yes, Malad. Malad, in this matter, private respondents, yeah, Malad. Private respondent, they have not yet appeared. Malad, may we
Service
please proceed to
complete.
the last order?
Hmm. 4, 7, and 8. Who is 4, 7, and 8?
The NHPC, Malad, may please to see the last order 26/11/2024. As per that order, Your Lordship, may I read just the the second two paragraph. It appears as per the order dated 5/11/2024, registry was directed to inform Mr. K. Saxena, Land Council, so that he may represent the respondent number 4, 7, and 8 on the next date. It appears that the said order has been communicated to the
No,
land.
Wakalatnama on behalf of respondent number 4, 7, and 8 has been filed already.
Okay, then my lord, the
Not
NHPC
contrary affidavit. State has filed.
Yes, Your Lordship.
Heard Mr. S. Mohan, counsel for the petitioners. Mr. Vairaram, London State Council submits that an affidavit in opposition has already been filed on behalf of the state.
Respondent number 9, Your Lordship.
Respondent number 9. It is noticed, next para, it is noticed that other respondents have not filed their affidavit in opposition. List for admission we have for 2 weeks, 3 weeks.
obliged.
Your Lordship. Your Lordship, service report in respect of respondent
Ever
number
service
6 to
report.
12 is still waited.
In respect of 6 to 12. List after
Your Lordship, I amplify that I may be given time to take a step, so that's the service.
Right.
Yes.
No, in that case, award service as per office note so and so. Office note dated 06/06/2025. Service report in respect of respondent 6 to 12. Still awaited. Mr. Garbach,
Yes, Your Lordship.
learned counsel for the petitioner pressed for and granted 3 days time to take precise steps, including by of testimony,
Yes,
list after 4 weeks.
obliged.
J. Garbach. J. Garbach.
May I plead?
Yes.
Well, in this matter, respondent number 1 and 2 have filed, but then private respondent have not filed yet. Okay. Well, this matter relates to non-payment of
Yes,
admitted bills.
respondent number 4 and 5.
Yes, 4 and 5.
For respondent number 3, Your Lordship.
You have filed already.
No, I'll be filing my affidavit. I'll be filing my affidavit, Your Lordship, if Your Lordship give some time.
303.
Yes, 4 and 5. 1 and 2. 1 and 2 has already filed.
Yes.
Yes, 1 and 2, yes.
And Mr. S. Mohan, counsel for the petition. Affidavit in this, on behalf of respondent number 1 and 2 has already been filed. Next para.
4 and 5.
And the prayer of MST Learned Council for respondent number 3. And 4 and 5, who is for?
4 and 5 is government is appearing.
And MS Arbasar Learned for respondent 5. Further 3 weeks time is granted to file affidavit. 3 weeks.
Obliged.
May I beg your lordship?
Yes.
Lordship, I am for the petitioner hearing. Lordship. The pleadings between the parties is over. Respondents have duly entered appearance, your lordship.
Pleadings complete. What is the matter?
Matter is, your lordship, there was a direction to held a Kebang, your lordship. Before the Kebang could pass an order,
Pleadings complete.
yes,
Heard Mr. So-and-so learned counsel for the, and Mr. Ketama learned counsel for the respondents.
Four.
Four. Who is for state? Yeah, so-and-so. Pleadings are complete. List for admission hearing after 3 weeks.
your lordship, there is an urgency, your lordship, because
2 weeks.
next week, your lordship, possible.
2 weeks.
Oblige, your lordship. Yes, your lordship.
Kaba has not been conducted.
Keba has been conducted, your lordship.
Against you.
Then-
It has
ADC
gone against you.
Order
It's
before,
against you.
no, your lordship. Before the Keba order could have been passed, your lordship, the respondent, he approached the ADC and ADC has stayed the entire Keba proceedings, your lordship. Now. This is the issue, your lordship.
Okay.
Against that order, we have challenged this. 2 weeks, your lordship.
Yes.
Oblige, your lordship.
Hey, please, your lordship, in this
Yes.
case, your lordship, we are yet to receive our Parawais
Heard so-and-so, further 3 week time is granted to MS so-and-so learned counsel for the estate counsel for filing affidavit.
Lordship, interim order. may be
Interim
continued.
order passed, LS will continue.
Oblige. Lordship, in this case also, we need 3 weeks time, lordship. 3 weeks time may be granted, lordship.
3 weeks.
Yes, lordship.
My lord, we may be allowed to take every step upon the respondent.
Is the interim order?
Yes, my lord.
We'll vacate it. Why you have not taken a step?
My lord.
Interim order passed on 26/11/2024. No steps till date. Heard Mr. So-and-so learned counsel for the petitioner.
Yes, my lord.
It is noticed that this court has granted an interim order on 26/11/2024. However, as on date, the petitioner has failed to take steps for service of notice upon responding member. 4. Although the court would have vacated the interim order passed earlier on having in view of the conduct of the petitioner, as a last opportunity on the prayer of Mr. So-and-so, learned counsel for the petition is granted 2 days time to take precise steps for service of notice upon respondent number 4. In case, in the event of failure to take precise steps, within 2 days, the interim order passed on 11, so and so, no, 24/11. 26/11/2022 is then automatically vacated. You take, if not, it will be vacated automatically.
Oblige.
This review. What is this review? What
Review,
review?
my lord, the review applicants are the Central Board of Secondary Education. My lord, so passed an order, my lord, wherein, my lord, a direction was given that initially, my lord, a writ petition was preferred, my lord, seeking for alteration of date of birth in the official documents of the writ petitioner, my lord. Then the direction was issued, my lord, and accordingly in compliance of the same, my lord, we were trying to, my lord, rectify the, my lord, the actual date of birth of the writ petitioner. Order was that, my lord, the direction was given to the writ petitioner to submit all the requisite documents before the principal of, my lord, government higher secondary school, and the principal was directed to forward to us those documents on the basis of which, my lord, we were to rectify the age, my lord. But, my lord, after passing of the judgment, my lord, twice we had written to the principal of government higher secondary school is coming, my lord. But on getting no response, my lord, we entrusted two schools who were affiliated to us, my lord, to conduct an inquiry and get the documents to, my lord, which establishes the age of the, my lord, writ petitioner. And then, my lord, certain documents came into this that the actual age of the writ petitioner was not, my lord, that she projected before the honorable court, my lord. New documentary evidence came before us, my lord. That is why we have preferred this petition, my lord, application. For instance, my lord, page 49.
Yes, sir. Any notice has been issued?
No, my lord. The first time, my
We
lord.
will issue notice.
My lord.
I mean, these are the problem.
My lord.
We entirely believe on the submission of learned counsel,
My lord.
and later when you approach by revision. These things makes us more alert
My
than
lord. Yes, my lord.
alerting the lawyers.
My lord.
Or Mr. So-and-so
I'm
learned
Vedas.
counsel for the petitioner. By decision, this review petition has been filed, seeking review of this petition is filed by the petitioner, seeking review of the order dated 3009/2024. No, we have relied on the
Documents that have
documents
placed by the writ
issued by the Department of Economics and Statistics, as well as transfer and school living
lord.
certificate
My lordship.
issued by the school.
My lordship. That is what, my lord. And the age that has been projected, my lord, 2000, the writ petitioner claimed that she was.
Are you
born.
saying that these documents are forged documents?
Because, my lord, that is why I was emphasizing, my lord, page 49, my lord, a document has been placed, my lord.
Page 49.
My lordship. Page
Yes.
49, my lord, Miss Pappy Gyari,
No, how do you rely on this?
29600. This has been placed by the writ
Sir, why
petitioner.
you cannot rely all this handwritten, I mean.
This has been my lord, placed by the
register.
writ petitioner, my lord.
We have relied on the documents issued by the authority, competent authority. This is a handwritten, I mean, entry in the admission.
Admission, my
No,
lord, placed by the writ petitioner. And same, my lord, page 91, my lordship may kindly see.
Issue notice returnable by 4 weeks. Then counsel for the petitioner takes steps for service of notice upon respondent,
My lordship,
sole respondent.
sole respondent.
Respondent. Barrister, person, and so and so.
This document shows at age 12, she
No,
appeared
you
in
cannot.
class 10, my lord.
Why you have not produced all these things earlier?
Now, my lord, we have got, that is what our case is, my lord.
These are handwritten.
Handwritten, my
entry.
lord. That was-
Entry by handwritten.
Yes, my lord.
There is a
that was-
certificate
This has
issued
been-
by the department,
These
your school, their school,
My lord,
principal school.
this is placed
principal
by
of
the
the
red
school.
petitioner, my lord. That
Huh?
is what our case is. Those are placed by the red
Anyway,
petitioners.
Let us
Deeply obliged.
Your lordship.
Yes.
Lordship, I'm appearing on behalf of J. Genie, your lordship.
What do you want?
Respondent B. Picha is out of station. This morning, he telephonically informed us to preparing for the accommodation of another date, your lordship. So matter may be fixed on next week, your lordship. Since pleadings are also completed hearing, lordship. Private respondent number 7, we have taken a dusty service and we have filed the affidavit also.
Or Mr. Swenson, let me counsel for the petitioner. An affidavit has been filed by the petitioner with regard to the steps for service of notice upon respondent number 7 by a dusty mode. And the same is taken on record. List of having considered that the where is the affidavit? Where is the receipt?
Lordship, today I was telephonically informed, your lordship.
Where is that affidavit of Dusty?
Dusty, we have filed, your lordship.
Which page?
Annexure 1, your lordship.
The respondent number 7. And then the power of attorney holder of the respondent number 7 has received the notice on 01/04/2025. Accordingly, the service in respect of respondent number 7 is complete. Further 3 weeks time is granted to the respondent to file affidavit.
Obliged, your lordship.
I think this will take time. We'll start at 2 o'clock. We'll take up at 2 o'clock. All right. You take others.
Ma'am, please. Lord.
Yes.
Lordship, additional affidavit has been filed just to show, my lord, the copy, dusty service upon the private respondent has already been taken, who refused to, my lord, accept the copy, my lord. To that effect, my lord, the affidavit has been filed, my lord. Now, service in respect of private respondent, newly implemented respondent is completed, my lord.
So he refused.
He blatantly refused to receive the copy, my lord.
Who is respondent number? Respondent number?
He is the beneficiary, my lord, respondent number 4, my lord.
Oh. What is the matter?
I'm sorry, page number, the respondent number 5.
Who is the matter? What is the matter?
Matter is, my lord, 1 day notice only, NIT note was issued and he got the, my lord, the work. Private respondent number 5, my lord. When the writ petition was filed, it was not known, my lord, to the petitioner, the work is, whom the work has been awarded.
Yes.
Now,
Respondent number 5.
5, my lord.
5 has been awarded the
Yes, ma'am.
work, contract.
Yes, ma'am.
So he refused.
He refused to accept.
How do we know? How do we,
My
how
lord,
do
to
we
that
accept
effect, my
that?
lord, we filed the affidavit on out, my lord. This is the only, my lord, procedure, my lord.
Next matter. I heard Mr. M. Kato, Learned Counsel for the petitioner. And Mr. Jitar, Learned Counsel for the standing counsel.
Yes.
For RWD, standing counsel RWD. For respondent 1 to 4.
1 to 4.
Next matter. The petition has filed an affidavit with regard to steps by with regard to notice by Dusty Moore. learned counsel for the petitioner. No, by filing the affidavit, it is stated that the respondent number 7 has refused to accept the notice list in view of the vote. The notice upon respondent number 5 is deemed to have been served accordingly. Service in respect of a service of notice in respect of respondent number 5 is complete.
My present, my.
Right.
Yes.
Yes.
If it is issued or not, he said it has been refused, he has, 5 has refused. Will deem it, sir. Is not it?
It is refused then.
Yes, or not, they are filing. What can we do?
No, my lord.
Is not it?
So,
Have you filed the affidavit?
not yet,
Further 3 weeks time is granted to file affidavit.
No, my lord, work is
2 weeks.
Work is
2
already
weeks.
going on, my lord. With the illegality in the Malada,
2 weeks. We'll grant them. Would like to see. You, what is your ground?
Well, ground is only one day not the NIT was issued and he got the work. Now they are saying that Malad work is in progress, so therefore there is no stay, Malad.
construction of school building.
Construct, Malad, admittedly,
There was
NIT
some
was
urgency.
floated only for one day, Malad. If Lordship peruse the Malad, the NIT.
We'll see 2 weeks. You file affidavit.
All
All right.
Deep level.
What is this?
Lordship, we have filed this IA, Your Lordship, for alteration and modification of the interim order passed on 2/11/22 by this honorable court, Your Lordship, in WPC 397 of 2022, Your Lordship. Lordship, may I kindly see
Where's the
the
order?
order, Your Lordship, at page 10, Your Lordship.
What is the direction?
Relevant paragraph is at page 13, Your Lordship. May I read, Your Lordship? Considering the contention raised by the petitioner that the land in question was initially occupied by his late father, Tanya Bam, in the year 1980 for an area measuring 2,500 square meters, and now the petitioner is in occupation and possession of 1,000 square meters of land, whereupon the petitioner has constructed his dwelling house and residing there with his family, and also having taken note of the fact that the land, including the land under occupation of the petitioner, is stated to have been donated by the villagers of Bamin Bilad for establishment of Bilad Circle headquarter only in the year 2002. Till the returnable date, it is provided that the impugn order dated 25/5/2022 passed by the estate officer Bilad East Siang District, wide such and such in case number so and so, as well as the order dated 14/9/2022 passed by the Deputy Commissioner East Siang District Pasigat in appeal case number such and such shall remain stayed, Your Lordship. So these two orders, Your Lordship, by the estate officer and DC has been stayed, Your Lordship.
So why you want to get it back?
Lordship, this actually this matter pertains to eviction of the petitioner from the encroached land, government land, which has been notified only already, Your Lordship. This land, along with the community land, has been donated by the Bilad Bamin villagers in the year back 1950-60, Your Lordship.
You are
And Tito Beg-
according to it's a government land.
Yes, we are saying government land, and he has not challenged the
Have you filed the
notification.
affidavit?
Yes, we have already filed our
Get
notification.
it
What he is,
disposed of.
Lordship, taking the advantage of this interim order, Your Lordship, he is constructing the,
Yes.
Your Honor, this morning I have received. and
Okay.
If I
Issue notice after a week.
maybe like
In the
for example,
meantime,
Friday, Your
in the
Lordship.
meantime, don't make construction.
The direction may be given, Your Lordship, not to construct
No,
any,
we'll take it after 1 week.
Lordship.
You want to file objection, we'll take it after 1 week.
and
Right. Hard
the
MS so and so,
ordinance-
land council for the petitioner. State council, this application has been filed seeking modification, alteration, publication of the interim order dated 02/011/2022. Passed in the WPC 397 of 2022. Issue notice. Next one.
Your Honor, this
Mr.
main case.
So and so. Learned counsel for the petition accepts notice on behalf of. Why with this opposite party of the great petitioner? Except enter appearance and accept notice on behalf of respond opposite party of the great petitioner. List after a week.
Your Honor, this
They-
main case,
Along with WPC.
Fixed date may be given, Your Lordship,
Pleading-
for final
Okay.
disposal.
this main case pleading has been completed, so final.
So that's why list
yes, Your
the after list the matter along with WPC 397
Yes.
397 of 2022.
On 16, Your Lordship.
After a week.
Okay.
After a week.
Right.
My lord, this is
Lordship, I'm appearing on behalf of BP Cha, Standing Council of RD.
This is for implement.
implicit, yes.
Who is private respondent?
Private respondent, Chera Tapung.
Who is there? Who is he?
Chera Tapung, he is the PTA EORE in charge of Panyasang at present.
What is the challenge in the writ petition?
The writ petition, the challenge is that since Yamra Tatu, who is also a PTA of Damin Jila segment and also holding the in charge of EORE, who was engaged on dated
This is regarding what?
regarding the transfer and posting, replacement of
Transfer and posting.
yes.
So who is this Chera Tapung?
Chera Tapung is also a PTA who is holding same post and position in different area, that is Panyasang.
What is his connection?
Panyasang is the
Why is there a party? Why it should be a party?
because it is as per the annexer 3 of this implement application, which is in page number 15. Here, the MLA, local ML of the Cloring is directing the authority to replace Yamra Tatu by
Chera Tatung.
yes by Chera
Tapung.
Tapung.
Okay.
Yes.
So is there any order to that effect?
Mm,
After the note by the MLA, where is page?
page number 15.
After this, there is any order replacing you by this Chera Tapung? You are Ramra Tatu.
Yes, I am Yamra Tatu.
Yes. Is there any order?
Yes, there is an order, engagement order dated, which is in page number 14 of annexer 2, dated 22 August 2024, where by the project director of rural development, Urungkume district has passed an order that Sri Chera Tapung PTA Panyasang shall be posted to the
In your
EO
place? In your
yes,
place?
yes.
And you have been sent to his place?
Yes.
Okay.
Whereas I have been
Heard Mr. So-and-so, learned counsel for the petitioner. The applicant oblique writ petitioner. And Mr.
T. Tharin on behalf of
So-and-so for, on behalf of Mr.
BP Cha,
B. Pitcher, learned counsel for the
Standing Council RD.
standing council, are the for respondent number 1 to 5. Opposite party respondent number 1 to 5. Huh?
3.
Respondent 1, 2, 4 and 5 and Mr. N. Loang, learned senior government advocate for respondent number 3. Next para. By filing this application, the petitioner has sought for implement of one Sri Chera Tapung serving as PTA cum EO within bracket, Ari bracket close. Panyesang, comma, in the district of Kurungkume, POPS Colonial in the district of Kurungkume, Arunachal Pradesh, list of having considered the submissions of Land Council for the parties and Land Council for the petitioner, and also the grounds for implement as ever in the application, as well as prayer not being objective to the Land Council for the respondents, state respondents, comma, I deem it appropriate to allow this application as the proposed a prospective as the said person who is working as PTA come EO Udin Badri Ari Panyasang, comma, Colonial appears to be a necessary party as the petitioner has been transferred in place of the above said person, and the petition and the said person has been posted, the transfer and posted in place of the petitioner. List of the accordingly the application, interview application is allowed. No, not according.
May I
the
note-
application,
Lordship,
introductory application is allowed, and accordingly the one series so and so, Cheraha, Tapu so and be allowed to be implemented at respondent number 6 in the connected. You say that connected for so and so, initial also connected writ petition.
And my lord,
54/2024 in initial for filing implement and connected writ petition. So first para and then last also. IA stands allowed in this.
my lord, there is some
In view-
typographical.
next para. And in the writ petition, in view of the order passed so and so in IA, the Land Council for the petitioners to file amended course title, list of thereafter the registry to incorporate the name of the newly inflated respondent number 6. List of thereafter steps be taken by the respondent, Land Council for the petitioner for service of notice upon respondent number, newly inflated respondent number 6 within 2 days. List the matter after 4 weeks.
My lord, there is some typographical mistake in my IA in the course title. That is in page number 2. If I may be allowed to make correction.
Which one?
Course title of this IA.
Which course title?
Yes, course title.
Which one?
Page number 2.
Yes,
in the matter of political recommendation dated 21/05/2025, where by the
it's okay.
local MLA.
It's okay.
Lordship,
Obliged.
there is a strong objection from the RD department, Your Lordship. He was proposed to condone this matter today. He will appear personally and he will argue on this IA regarding this IA. He has a strong objection, Your Lordship. So
See,
hearing,
he is a necessary party.
yes,
He has been, you are agreed by your transfer order.
No.
What?
My lord,
What is the writ petition?
in my writ petitions, my lord,
Challenge is what?
challenging the transfer of.
That's why your
Yes.
the person whom you have sought to be implemented,
Yes.
he has been sent to in your place,
Yes.
and you have been transferred to
His
in his
place.
place. So you are challenging the transfer only.
Yes.
Then
Lordship, I'm requesting for fix this matter on Tuesday, Your Lordship. Then he will be available.
no, I pass the order. He is a necessary party. He is challenging the transfer order, right?
Yes.
Okay.
Obliged.
Ah,
Obliged.
Wait,
yes.
I would have filed the amended interrogatory application.
Amended.
Yes. Which was allows ballots.
Which, if it is allowed, is allowed.
Yes, we have filed it.
Hmm.
Now, my lord, is that application under order 7 rule 11 of the CPC.
Hmm.
For rejecting the election petition for not disclosing post election.
Hmm.
Now the election petition has been filed for declaring the election of the returned candidate void, my lord.
Hmm.
Under 100, that is for wrongful acceptance and for corrupt practice.
Yes.
The prayers are made under 100B, then 100D1, that is improper acceptance, 100D2, that is by corrupt practice, and 100D4, non-compliance of provisions of Constitution and of this Act. Now, my lord knows there are around specifically 10 paragraphs, my lord, though they have tried to do it in 2 parts, but paragraphs are conjoined this way, that way, like that, my lord. First part, I understand that there's a wrongful acceptance. Second part is corrupt practice. Now, my lord, for wrongful acceptance, I have understood on what the Honorable Supreme Court has held is there has to be aberrance in the election petition to show, my lord, as to how the result so far as the return candidate is concerned, my lord, has been materially affected.
Yes.
Now, in the election petition, my lord, there is absolutely no aberrance how it has been materially affected. Now, as far as corrupt practice is concerned, my lord, vague and bold statements, and I'm reiterating again, so far as improper practice is concerned, they did not even submit the written objection at the time of scrutiny. There was no written objection. That is there in the pleadings. I will show it. What they have brought in now is by way of this election petition, which was not before at that time before when the scrutiny was being taken up. So there was no question of, my lord, adjudicating upon some objections, so that now there is an improper acceptance of the nomination papers. Now, if your lordship, my lord, may kindly have for a moment, my lord, representative of people at few sections, my lord. Your lordship may kindly have section 36 for a moment first.
Yes, scrutiny of nomination.
Yes, scrutiny of nominations.
Hmm.
I will come directly to 2. The returning officer shall then examine the nomination papers and shall decide all objections which may be made to any nomination and may either on such objection or on his own motion after such primary summary inquiry, if any, he thinks necessary, reject any nomination paper on the following grounds. A, that of the date fixed to the scrutiny of nomination, the candidate either is not qualified or is disqualified from being chosen to fill the seat under any of the following provisions applicable, namely such and such and such. B, that there has been a failure to comply with any of the provisions of section 33 or section 34, that the signature of the candidate or proposer of the nomination paper is not genuine. These are not there. Now, what has been sought to be made out in the election petition is that some properties were not disclosed, but there is no assertion that how the non-disclosure of such properties, I am not, because at this moment I will rely only on the plate. Such disclosure, non-disclosure of such property has materially affected the result of the election. There's absolutely no pleadings to that effect. There are pleadings, I will take a lordship to that. There are pleadings that I did not disclose some bungalow that I had availed as a MLA. And the no dues in respect of the water, telephones and all this are not there. but there is no assertion that there were actually dues pending. There are no assertion to that effect. There are judgments of the Supreme Court on that. There is no assertion to that effect. The Lordship will kindly have paragraph 83 of the petition. Of the Act. Contents of the petition.
83.
83.
Yes.
An election petition shall contain a concise statement of the material facts on which the petitioner relies. B. Shall set forth full particulars of any corrupt practice that the petitioner alleges, including a full statement as possible of the names of the parties alleged to have committed such corrupt practice and the date and the place of commission of such practice, and shall be signed such and such. Now, my lord, I will take your lordship through the pleadings. As far as corrupt practice is concerned, there are only bald and sweeping allegations. Not a single person named. I will just give you an example. There is a paragraph that says that one of my relatives was on duty at the polling station. He made hand signals. So one of the voters has informed me.
Hand signal.
Hand signal. The pleadings are there to the effect that one of the voters informed
Like
me.
this.
Yes, like this. I don't know this way or this way. That if that hand signal was not given, I would not have voted for the returned candidate. Who is that person? No name. How many were there? Nothing is there. So these are the type of averments as far as corrupt practices are concerned.
So the voters are so gullible.
Yes. This is what I'm trying to say. Because it says, including a full statement, and my lord knows what the Honorable Supreme Court says. Even a single fault, my lord, a single material not being disclosed would make it liable to be rejected under 711.
Yes.
Now, just for a moment, just one more section, my lord. 123.
Yes.
Corrupt practice. What are corrupt practices? The following shall be deemed to corrupt practices for the purposes of this act. Bribery, that is to say, any gift otherwise or promised by a candidate or his agent or by any other person with the consent of a candidate. My lord will kindly note this. Consent of a candidate or his election agent of any gratification to any person whatsoever with the object directly or indirectly of including a person to stand or not to stand, as to withdraw or not to withdraw from being a candidate in election, or B, an election to vote for or refrain from voting in an election, or as a reward to a person for having so stood or not stood, or for having withdrawn or not having withdrawn his candidature, or an elector of having voted or refrained from voting. B, the receipt of an agreement or to receive any gratification, whether as a motive of a reward by a person for standing or not standing as, or for withdrawing or not withdrawing from being a candidate, or by any person whomsoever for himself or any other person for voting or refraining from voting, or inducing or attempting to induce any elector to vote or refrain from voting, or any candidate to withdraw or not to withdraw his candidature. Undue influence. Undue influence, that is to say, any direct or indirect interference or attempt to interfere with the part of the candidate's agent or any other person with the consent of the candidate's agent with the free exercise of any electoral rights. So these are the 1 and 2, this is we are concerned with. None of the allegations men in fact falls under this.
Bribery. 123.
123, 1 and 2, corrupt practice and undue influence.
Okay.
He is alleging corrupt practice and undue influence. Undue influence basically to the voter. To the voters.
Okay.
Now, as far as the corrupt practice is concerned, there has to be, my lord, the petitioner is required to make concise statements, my lord, of material facts as to how the return candidates indulge in corrupt practice, of undue influence by directly or indirectly interfering or attempting to interfere. That pleading has to be there. I will show from the pleadings, my lord, as far as corrupt practice is concerned, it is so vague that it has to go, man. I'll take your lordship to the pleadings, my lord. Your lordship may kindly have the election petition. This is basically paragraph 19 to 21. 19 and 20 subparagraphs. Page 25.
Yes.
They have heading, put it in heading, material facts and particulars with regards to corrupt practice of undue influence, non-disclosure of assets and liabilities in affidavit in Form 26 that has materially affected the result of election to successors. So in fact, they have combined it, undue influence as well as improper acceptance. That is what I have understood. Subpara 1. That it is mentioned in note 2 of paragraph 7b of Form 26 that each land or building or apartment should be mentioned separately in this format. However, returned candidate had not only committed an apparent error in numbering the paragraph, but also made a false declaration by not disclosing the complete information with regard to the said paragraph. The returned candidate, in his Form 26 affidavit, had incorporated subparagraph A twice instead of subparagraph B. So the allegation is regarding to form. In paragraph 7, which deals with details of immovable property assets. Further, the returned candidate in paragraph 7 of his Form 26 affidavit had failed to disclose his residential flat measuring 1200 square feet on the 4th floor of Beledel Enclave, building at 3 number Matgodia, Moja Beltola under Dispur such Assam, the information of which the election petitioner has obtained from the concerned authority. Such non-disclosure of property worth during the time of purchase for which return candidate has paid additional stamp is a defect of substantial nature which has materially affected the result of the election. He says a defect of substantial nature which has materially affected the result of the election. How it has materially affected the result of the election so far as the election returned candidate is concerned, there is no pleadings to that effect. This I understand is regard to improper acceptance. I understand. This is what the paragraph means. This allegation is in regard to improper acceptance, 19.1. If improper acceptance, there has to be pleading to the effect, categorical pleading to the effect as to how this non-disclosure has materially affected the result of the election so far as the election of the returned candidate is concerned. I will place judgments on that. 2. That the petitioner states that he made an RTI application dated 10/6/2024. By note, kindly note, the date of scrutiny was 28/3/2024. Under the RTI Act, seeking information regarding the details of government accommodation availed by the respondent number 1, Dr. Mohesh Chai, for a period from June to May 2019 in response thereto, the Joint Secretary cum PIO Legislative Assembly had furnished a RTI reply dated 20/06/2024, which clearly shows the allotment order number such and such issued by the Secretary, Pradesh Legislative Assembly in favor of the respondent number inter alia MLA Kotes, E Sector, Arunachal Pradesh. As such, from the perusal of the aforesaid information obtained under RTI Act 2005, it transpires the respondent number was in occupation of government accommodation during the last 10 years before the date of notification of the current election. However, he had only disclosed that he had availed Bangalore number 3 from 2017 to 2019. He had not disclosed the MLA Cottage number 2, East Sector Itanagar, which had been availed during the year 2014 to 17 and had thereby made false statements and given false declarations in serial number 2, wherein he had mentioned the address of the government accommodation, Bangalore number only, and he also mentioned nil regarding the dues payable in respects of the aforesaid government accommodation towards rent, electricity, water charges, telephone charges as on 27/3/2024. First thing is, my lord, this is something that was not raised at the time of scrutiny. This, I believe, is also a paragraph pertaining to improper acceptance, because there is no allegation of corrupt practice here. This is an information they got on their application dated 10/6/2024 on being furnished on 20/6/2024. So this allegation was not before the returning officer at the time of scrutiny. That was on 28/3/2024. Further, there is no assertion that I had dues in respect of Bangla number 2, Bangla number 3, towards rent, electricity, water charges, and telephone. There is no assertion. And there is also no pleadings again here to the effect as to how the result of the election insofar as the return candidate was materially affected by improper acceptance of the nomination. That pleading is also not available here again.
Yes.
Further, the return candidate did not submit no due certificate from the concerned authorities, agencies in respect of the same. By the non-disclosure thereof, the return candidate has not made false.
These are to be all disclosed in the
No.
Form 26.
Yes, if I have availed, if I have dues, then I have to disclose it. Form 26. That is why I was pointing out. He only says that I have not disclosed it. He does not say.
Basically, Form 26.
Yes.
Nothing,
Yes.
whatever declaration
Yes.
statement is a false statement
Yes.
or declaration,
Yes.
according to him, which has materially affected the election.
Yes.
of
This
the
is
return.
improper acceptance, I believe. This paragraph pertains to improper acceptance, it appears so. Because
Yes.
what he's saying is by non-disclosure. The return candidate has made false statement and has given false declaration in his Form 20 affidavit submitted with his nomination paper for the election of such and such. The same is a defect of substantial nature as per such and such. The same has presented the false picture of the respondent number 1 as a person who did not avail MLA quotas, thereby materially affected the prospects of the petitioner in the election petition. No pleadings as to how the result, so far as the return candidate is concerned, the same has been materially affected. Basically, the objection is to form.
Substance is of improper acceptance of the
Improper
nomination.
Appears.
Right.
That is why I'm submitting. If it is an allegation of improper acceptance, there will have to be an averment, categorical averment. How, my lord, my not disclosing Banglaw number 2 and as to whether I had dues in respect of, my lord, water charges, rent, telephone, etc., my lord, has materially affected the result of the election so far as the return candidate is concerned. That pleading is not there. I understand, my lord, Karimuddin Bhorbuya, in fact, our High Court judgment that went to the Supreme Court squarely covers it. And basically, the objection is to form. No assertion, my lord, no assertion that the improper acceptance has materially
Details
affected.
of immovable property not known. Expose, expose,
Next one, my lord.
yes,
Yes.
movable assets. I mean,
That paragraph such and such, details of movable assets and details of immovable assets respectively. And a candidate is mandatorily required to furnish the details of the same. However, respondent number 1 had neither disclosed the details of the movable asset nor disclosed the details of immovable asset exposed number 1 and had mentioned not known. As spouse number 1 has declined to share any information to me due to our estranged relationship because of my marriage with spouse number 2.
yes, basically Form 26.
Yeah,
Yes.
Form 26. This is
Yeah.
also in respect of improper acceptance.
Yeah.
Now, my lord, Supreme
So
Court is
they-
clear. So the only thing I have to say is no, nil or nil not known. If I don't know, how can I, my lord, fill it up?
So details of the spouse.
Yes, yes.
Spouses are here.
Yes.
Page 31.
This detail he has furnished in respect of the 2019 election. That time I did not marry a second wife, my lord. So the relationship was okay. So I had the information. I have duly furnished it
These details are is by,
from the 2019 election.
how is he obtained it from that election, affidavit
Yes,
of the
yes.
election.
From this uploaded in the, that is not an issue. So this is also in respect of, my lord, improper acceptance. Here also, there is absolutely, there, my lord, kindly come to page 36,
You could have given this last one.
my lord.
You have not disclosed anything about this.
No, my lord.
First spouse.
No. We have, in each and every column, my lord, we have said, not known. This is permissible as per the Supreme Court, if I don't know. Because this table A that the election petitioner is furnished are in respect of, my lord, the earlier election, 5 years back. These are movable and immovable assets. Movable assets, there are every chance, my lord, that has changed. Immovable assets also, there are every chance that it has been, my lord, disposed of. Now, if I fill it up on the basis of the last election, they would amount to giving false information, my lord. This I did not know. I have.
Then vehicle.
Yes.
Vehicle also.
Then, my lord, vehicle. That the respondent number 1 return candidate did not disclose the details of vehicle. My lord, this subparagraph 3. Subparagraph 3. It appears to be, my lord, improper acceptance, but they have mentioned corrupt practice. Now, if it is a corrupt practice, the allegation is corrupt practice, then there will have to be, my lord, assertions that how such non-disclosure has materially affected the results of the elections. There is not there. Then 4. That the respondent number 1 did not disclose the details of vehicle registered to name of his spouse number 1. It's the same thing, my lord, as far as the spouse number 1 is concerned. And Srimati Chapang Luang, that is the spouse number 2. So this there is a scooty.
Yes.
So this also pertains to improper acceptance. Now, as far as spouse number 1, we have already said in the form that is affidavit not known because of such and such. And spouse number 2 allegation is there was an scooty that was owned by the spouse number 2. Now, here also, my lord, will kindly see again, there is no affirmation to the effect as to how the non-disclosure of that scooty, my lord, purportedly owned by my second wife, has materially affected the results of the election so far as the return candidate is concerned. That being not there, my lord, is liable to be, my lord, rejected under 711. The next paragraph onwards in respect to respondent number 2, I will not bother your lordship with that. Then, my lord, will have page 44. In fact, the election petitioner's earlier case before the Supreme Court, my lord, covers my whole case. Page 44. Material facts and particulars of corrupt practice of undue influence committed by the respondent number 1, respondent number 2, and respondent number 3. I am concerned respondent number 1. So this is totally corrupt practice. That the respondent number 1, return candidate, had engaged his band, agent and supporters to distribute election freebies and money to the voters of 44 Teju ST Assembly constituency, more particularly Jeko village. Well, we see how it is caught. To voters of 44 Teju Assembly constituency, more particularly Jeko village. In one such instance, Sri Thompson Boje, who was the supporter and polling agent of return candidate 31, was found to be indulged in distributing money at the behest of the return candidate. As a result, the petitioner secured fewer votes from Jeko village. Further, the sector magistrate, along with Flying Square and Arunachal Pradesh police, had seized an amount of rupees 17 lakhs from Sri Thompson Boje, who was carrying the same amount in vehicle number substituted at around such and such. One of such supporters, might will kindly note this. One of such supporters from Jeko village who had voted for the return candidate had informed the election petitioner that he had not received certain sum of money from Thompson Boje at the behest of the return candidate, he would not have voted for the return candidate. One such voter, who is that voter, my lord? It is not named. My lord has seen section 83(2). What is the amount? Not disclosed. How many voters were, my lord, bribed? Nothing is there. Hence, the above mentioned corrupt practice of undue influence committed by return candidate in connivance with this polling agent has materially affected the result of the election in question. So, a sweeping allegation, nothing particular is there. Who are the voters? How many voters? Who the voters? What is the amount paid? Absolutely nothing. Number two is in fact totally irrelevant. The Sri Sokhep Kri, who is working as State Gazetteer, Government of Arunachal Pradesh head and Director, Department of Indigenous Affairs, at the behest of returned candidate, had held a press conference through local news channel, which Divinity Jagran, on 17/4/2024, where he had leveled serious allegations against the petitioner. That is somebody else. Where he has against the petitioner and his son's involvement in the official raid undertaken by Flying Squad team and Arunachal Pradesh police in his residence at Tezu on 16/4/2024. The said person, who is also the brother-in-law of the returned candidate, went on to blame the petitioner for such official raid undertaken by authorities concerned. As such, the petitioner, being the law-abiding citizen, sought clarification from the district election officer Lohit whether he has any involvement in the said raid as alleged by Sri Sokhep Kri. It is also pertinent to mention here that many such official raids took place at 44 Teju ST Assembly constituency, which includes the house, the supporters of petitioners, such and such, such and such. However, neither the petitioner nor any of his men, agents, and supporters had raised any questions against the officials concerned or tried to defame any contesting candidates. Hence, it is crystal clear that Sri Sokhep Kri had intentionally held the press conference at the behest of his brother-in-law, thereby disregarding his avowed duty to public as public servant in the capacity of director, indigenous government of Arunachal Pradesh. While doing so, Sri Sokhep Kri had called the petitioner a criminal, virus, dangerous to civil society and communal harmony, and appealed to the voters of the said constituency not to vote for the petitioner in furtherance of strengthening the winning prospect of the returned candidate. As a result, he had influenced the Missimi community in voting against the election petitioner. Being aggrieved by the same, the petitioner made reference such and such, such and such. However, the same has not been considered by the authorities concerned. As a result, it has materially affected the result of the election in question. Therefore, an incident of corrupt practice of undue influence committed by the returned candidate in connivance with his brother-in-law was captured by video recording of such and such in public domain, which will, with the leave of the court, would submit in pen drive with the status of production of documents during the course of the trial. How can this even be attributed to me, man? This allegation is not even against me, though there is a line that at the behest of the petitioner. And how does it come under corrupt practice, man? Undue influence. The allegation, my lord, is against one Sokhep Kri. Just because he says, with the consent of the returned candidate, does not mean anything, because there is no disclosure, my lord. How, my lord, that consent was given? When did I give that consent? Absolutely nothing, my lord.
Yes.
These are bold and sweeping allegations. There is no material particular to even tie me to. So once this Sokhep Kri, that I had, my lord, directed him to do this whatever so-called interview with whatever channel, because there is no particulars. He has not said anything. He just says at the behest of the returned candidate. That's all, nothing else. The Honorable Lordship have subparagraph 3. That the fourth polling officer of polling station number 15 is the nephew of the returned candidate, late such and such, and our sons of such and such, who was in the said polling station of 44 Teju Assembly constituency in the capacity of fourth polling officer and had influenced the voters. Which voters? By gesture or sign. This was the paragraph I was talking about. In favor of the returned candidate. Now I will again see the manner in which the petition is crafted. One of such voters who was influenced by sign and gesture of the said person inside the polling station booth number 15 had informed the election petitioner that had he not been influenced by the said person, he would not have voted for the petition. Who is that person who had informed the election petitioner? And what was the sign? The fact of Sri Rajesh Chai being deputed as fourth polling officer has been verified and ascertained by the petitioner through RTI reply furnished by the public information officer through district election officer Teju. Amongst other complaints, the same was also brought to the notice of the returning officer However, the same is yet to be concerned. This is meaningless so far as the election petition is concerned. There is absolutely no material matter disclosing a cause of action matter of corrupt practice here. Because 83(2) is not complied with. Absolutely no material particulars. Voters
Yes.
voters were influenced by gesture and signs.
Hmm.
How many voters? He says, one of them told him,
Hmm.
he does not name him, same like paragraph 1, my lord. So this does not disclose any corrupt practice, my lord. This does not fulfill the conditions laid down in section 83(2) of the RP Act. Then your lordship will have page 51, 4, subparagraph. That the instances of double voting casting of votes were found in various polling stations in 44 Tejo Assembly constituency, which had been informed to the petitioner by the polling agents of the said polling stations. As such, being highly aggrieved by the same, the petitioner filed a representation to the district election of the returning officer, Assembly constituency, such and such, for trying out such and such of the above named 43 persons by representation dated 24 and 27/5/2024. Now, at the very beginning, he does not even name which was the polling station where this double voting casting was done.
Yes.
In against whose voter double casting was done, nothing is disclosed. Absolutely nothing. However, authorities concerned utterly failed to consider the same, as such the result is materially affected. This paragraph, how does this comply with the mandate of section 83(2), this paragraph? Subparagraph 4.
Yes.
5. That as per the election notification number such and such, the polling date was scheduled on 19/4/2024. The polling date was 19/4/2024. Accordingly, the polling started at 7 a.m. in the polling booth number 3, Tafragam 7, Government Teju number 112, Government such and such, as per the scheduled date under notification. However, the voting of the state polling stations lasted until 5 a.m. on the next day, that is 20/04/2024, in contravention of the notification dated 20/03 issued by the Election Commission of India itself. Further, there was complete blackout in those polling stations as well as the Teju Township for around 15 minutes at around 9 p.m. due to power cut, and no alternative arrangements were made by the authority concerned. As a result, some of the voters, including women and old age voters, could not exercise the adult franchise. I pause here against sweeping statements. Who, how many, nothing. He's not even saying that during the blackout, this happened, that happened. Then again says, few of the voters who could not cast their vote informed the same to the petitioner.
Yes.
Again, not named who were there. In pursuant thereto, the petitioner had brought to the notice of the authorities concerned of the said incident by letter dated 30/05/2024. Polling was done on 19, my lord, and they had 19/4, after more than a month. However, the same has not been considered by the concerned authorities. Later it was found that the polling booth number 3, the official record per Form 2C of casting were 909 votes, whereas electronic voting machine recorded 907 votes. So it's difference of 2 votes. Further, the EVM of polling booth numbers was not counted on the ground that there was mismatch discrepancies in Form 17C, Part 1. Accounts of vote record. The same was also brought to the notice of the authorities to the session. Therefore, the corrupt practice had materially affected the result of the election in question. Therefore, the incidence of corrupt practice was is told in the above reply such and such. Teju, Arunachal Pradesh, with the leave of the court, we submitted the pen drive during the course of the trial. Now he does not disclose. So assuming this is true, because it's a 711 application, he does not disclose how much vote, assuming this government higher secondary of Tamla Nagar, how much votes were polled there, and how not counting there has affected him. Because it is on record, as per their own documents, that the return candidate won by 2,805 votes. The only discrepancy shows is 2 votes. So these are the paragraphs. And then my lord, kindly have paragraph 21 and 22. This I am reading because this is exactly what has been reproduced by the Honorable Supreme Court in the election petitioner's case. On the last occasion, the election petitioner's election was interfered by this Honorable Court. Even though the Supreme Court won there, it is exactly the same matter. Scooters, vehicles were also there.
Yes.
He did not disclose his bungalow also. It's the exact same facts and circumstances.
Yes.
And these 2 paragraphs have been quoted by the Honorable Supreme Court. It states that the corrupt practice undoing committed by with full connivance and support return candidate with the active returning officer is materially affected, such and such, such and such. This is a format paragraph, nothing more, nothing less. No materials, no facts, nothing. They being highly aggrieved by the corrupt practice, the respondent number 1 as well as such and such, the important and such and such, thereby better the legislative assembly, rendering the said election declared void, the petition is being duly as such. 21 and 22. 19, 20 at the subparagraphs, 19, 20 subparagraphs, 21 and 22. 21, 22 is a format paragraph, nothing, there is absolutely nothing here. Now, as far as corrupt practice is concerned, your lordship knows, the Honorable Supreme Court time and again has been categorical. There will have to be material facts disclosing a cause of action. And the mandate of section 83(2) has to be complied with. My handout I have shown as far as the corrupt practice part is concerned. There is absolutely no material facts. There are just sweeping statements. This and that. So this because of this, such voters were influenced. How many voters? Nothing. Some voter has told me no name, nothing. This is the manner in which the paragraphs are constructed. So absolutely, in my humble submission, my lord, absolutely no cause of action, my lord, has been disclosed in the election petition, liable to rendering it liable to be rejected under 711. Now, as far as this,
No cause of action, not to talk of full particulars.
yes, ma'am. And as far as undue improper acceptance is concerned, your lordship may kindly have a look at paragraph 9 for a moment, page 15.
Yes.
That the scrutiny of nominations.
Page
15, paragraph 9. That the scrutiny of nominations submitted by the candidates of the election to the legislature was conducted on 28/3/2024 in the office chamber of the Additional Deputy Commissioner Teju for the election to the said constituency. The election petitioner by counter affidavit at the time of scrutiny and objection letter that is submitted to the Sergeant during the time of the student had pointed out certain substantial defects which are tantamount to false statements and false declaration in his affidavit submitted in his nomination paper. The said counter affidavit at the time of scrutiny and objection letter was duly received. However, in spite of putting out substantial defects submitted along with the nomination paper, had arbitrarily refused to consider the same after accepting the nomination suggested election approach the court in the form of election petition, if at all. He was agreed by the decision of the returning of the material of the particulars of corrupt practice are placed hereafter in the instant petition. So the particulars are there in paragraph 19 and its subparagraphs and paragraph 20 in its subparagraphs. Now, I would like, my lord, to rely upon few judgments of the Honorable Supreme Court, my lord. Copy. Yeah. All judgments are in fact connected on corrupt practice as well as improper acceptance.
How many judgments?
I will rely on 4.
Latest and nearest. Latest and nearest to the issue.
Yes, ma'am.
Otherwise, there are so many judgments.
Yes. I will then, my lord, start from Rajiv Gandhi's case, 1987, Supply SCC 93.
In some other cases, it took me 1 month to go through all those judgments.
I will not rely upon much.
10 judgment, 15 judgments, very difficult.
I will not bother Rosas with that.
At the end of the day, only 2 judgments are required to be looked into.
In fact, my lord, this 2024, 2 judgments of 2024, SSC online, Karamuddin Borhuya and Kariko Kris case, these two should in fact cover it.
No, if it's covered, then why you should go into all those other things?
This I will just point out then. 1987 Supply SSC, page 93, paragraphs 8 to 15.
Just wait. There are 8 to
15.
15. There's
And 18. Well, I will read from paragraph 10
Yes.
at page number 104.
Hmm.
In Udhav Singh versus Madhavrao Scindia, this court held that failure to plead even a single material fact leads to an incomplete cause of action, and incomplete allegations of such a charge are like to be struck off under Order 6 Rule 16 Code of Civil Procedure. If the petition is based solely on this allegation suffer from lack of material facts, the petition is liable to be summarily rejected for want of cause of action. In Charanlal Sahu versus Gyani Jail Singh, an election petition challenging the election of Gyani Jail Singh, precedent was rejected summarily at the initial stage by the Constitution Bench of this court on the ground that pleadings contained in election petition, even if assuming to be true and correct, did not disclose any cause of action for setting aside the election of the returned candidate. The precise question is raised by the appellant was considered at length by this court in Azhar Hussain versus Rajiv Gandhi, and this court held that the High Court, while dealing with election petition, has power to strike out pleadings under Order 6 Rule 16 and to reject the election petition under Order 7 Rule 11 if the petition does not disclose essential facts to clothe it with complete cause of action. Failure to plead even a single material fact would amount to disobedience of the mandate of Act 3(1)(a). An election petition could therefore be and must be dismissed if it suffers from any such vice. The court repelled the submission that the power to reject an election petition summarily under the Code of Civil Procedure should not be exercised at the threshold. The court observed as under. In substance, the argument is that the court must proceed with the trial, record the evidence, and only after the trial of the election petition is concluded that the power under the Code of Civil Procedure for dealing appropriately with the defective petition which does not disclose cause of action should be exercised. With respect to the learned counsel, it is an argument which is difficult to comprehend. The whole purpose of conferment of such powers is to ensure that the litigation, which is meaningless and bound to prove abortive, should not be permitted to occupy the time of the court and exercise the mind of respondent. The sword of Damocles need not be kept hanging over his head unnecessarily without point or purpose. Even in an ordinary civil litigation, the court readily exercises the power to reject the plaintiff if it does not disclose any cause of action, or the power to direct the concerned party to strike out unnecessary, scandalous, frivolous, or vexatious parts of pleadings, or such pleadings which are likely to cause embarrassment or delay the fair trial of the cause of action, or which otherwise an abuse of process of law. An order directing a party to strike out a part of pleading will result in the termination of the case arising in the context of the said pleading. The court, in exercise of the power, of course, it can also treat any point going to the root of such as the one pertaining to jurisdiction or maintainability as a preliminary point, and can dismiss a suit without proceeding to record evidence and hear elaborate arguments in the context of such evidence. If the court is satisfied that the action will terminate the view of merits of the preliminary point of objection, the contention that even if the election petition is liable to be dismissed, ultimately it should be dismissed only after recording evidence is truly misconceived and untenable argument. The power in this behalf are meant to be exercised to serve the purpose for which the same has been conferred on the competent court, so that the litigation comes to an end at the earliest and the concerned litigants are relieved of the psychological burden of litigation, so as to be free to flow their ordinary pursuits and discharge their duties, and so that they can adjust their affairs on the footing that the litigation will not make demands on their time or resources, will not impede their future work, as they are free to undertake and fulfill their commitments. Such being the position in regard to matter pertaining to ordinary civil litigation, there is greater reason for taking the same view in regard to matters pertaining to elections. In Bhagavati Prasad Dixit, Ghorewala versus Rajiv Gandhi, this court again reiterated that in an election petition, pleadings have to be precise, specific, and unambiguous, which there is all manner in the election petition.
And if the election petition does not disclose the cause of action, it should be rejected in limine. These authorities have settled the legal position that the election petition is liable to be dismissed in limine at the initial stage if it does not disclose any cause of action. Cause of action in questioning of validity of election must relate to the grounds specified in section 100 of the Act. If the allegations contained in the petition do not set out grounds of challenge as contemplated by section 100 of the Act, and if the allegations do not conform to the requirement of section 81 and 83 of the Act, the pleadings are likely to be struck off and the election petition is liable to be rejected under Order 7, Rule 11. The pleading, if vague and general, is embarrassing. If the allegation contained in the election petition, even if assuming to be true and correct, do not make out any cause of corrupt practice or any ground under section 100 of the Act, the pleading would be unnecessary, frivolous, and vexatious. It is always open to strike no cause of action remains to be tried. It would be duty bound to reject the petition under Order 7, Rule 11 of the Code of Civil Procedure. If a preliminary objection is raised before the commencement of the trial, the court is duty bound to consider the same. It need not postpone the consideration for subsequent stage of the trial. The appellant placed reliance on the decision of this court in Union of India versus Surjit Singh Atwal. In support of his submission that unless the plea is raised by the respondent in the written statement, it is not open to the court to strike out pleadings contained in the election petition. In Surjit Singh Atwal's case, plaintiff had filed the matter. We are not concerned with this. We can skip this. Paragraph 13. The appellant's grievance there in entertaining the preliminary objection and rejecting the election petition under Order 7, Rule 11, the High Court deprived the appellant's opportunity to amend the petition and make good the deficiencies by supplying the necessary particulars and details of corrupt practice alleged in the petition is devoid of any merit. Firstly, the appellant are free to file amendment application, but at no stage he expressed any desire to make any amendment application, nor made any application to the effect before the High Court. It was open to the appellant to have made any application, but he himself did not make any such application. The High Court was under no legal obligation to direct the appellant to amend the pleadings or suo motu grant time for same. Secondly, the allegation of corrupt practice as required in Act 3 were not complete and the same did not furnish any cause of action. Any amendment made after the expiry would not be permitted, which would amount to raise a new ground of challenge. The question, however, does not arise if the appellant did not file any such and such. Before we consider the various paragraphs of the election petition to determine the correctness of the High Court order, we think it necessary to bear in mind the nature of right to elect, the right to be elected, and the right to dispute election and the trial of election petition. Right to conduct elections or to question the election by means of an election petition is neither a common law nor fundamental right. Instead, it is a statutory right regulated by the statutory provisions of the Representation of People in 1951. There is no fundamental or common law right in these matters. This is well settled by a career of decisions of this court in such and such, such and such. These decisions have settled the legal position that outside the statutory provisions, there is no right to dispute an election. The Representation of People Act is a complete and self-contained code within which any rights claimed in relation to an election or an election dispute must be found. The provisions of the Civil Procedure Code are applicable to the extent as permissible by Section 87 of the Act. The scheme of the Act, as noticed earlier, would show that an election can be questioned under the statute as provided by Section 80 on the grounds as contained in Section 100 of the Act. Section 83 lays down that the mandatory provision in providing that election petition shall contain a concise statement of material facts and set forth full particulars of corrupt practice. The pleadings are regulated by Section 83 and it makes it obligatory, but you kindly notice, it makes it obligatory on the election petitioner to give the requisite facts, details, and particulars of each corrupt practice with exactitude. It is precise and accurate. If the election petition fails to make out a ground under Section 100 of the Act must fail at the threshold. Allegations of corrupt practice are in the nature of criminal charges. It is necessary that there should be no vagueness in the allegations, so that the returned candidate may know the case he has to meet. If the allegations are vague and general and the particulars of corrupt practice are not stated in the pleadings, the trial of the election petition cannot proceed for want of cause of action. The emphasis of the law is to avoid a fishing and robbing inquiry. It is therefore necessary for the court to scrutinize the pleadings relating to corrupt practice in a strict manner. Paragraph 15, my lord, is just how the facts in the election petition did not disclose any cause of action, my lord. My lord has seen, my lord, how the allegations of corrupt practice are, my lord, as far as these petitions are concerned. as far as this petition is concerned. It's all vague, what is the material part, absolutely nothing is there. Then, my lord, I will rely upon 2024 SCC online SC 509. This is from our High Court. The application under 711 was rejected by this High Court. But it's Honorable Court.
2024.
SCC online SC 509. Ultimately, on appeal, my lord, the same was allowed by the Supreme Court. I start from paragraph 11. Paragraph 11 onwards. Paragraph 11, my lord, what is corrupt practice is again reproduced. This, my lord, in my humble understanding, my lord, this case covers my case. On improper acceptance as well as corrupt practice. Paragraph 12, I read. At the outset, page number 9.
Yes.
Paragraph 12. Page 5.
Yes, yes.
At the outset, it will be noted that as per a well-settled legal position, right to contest election or to question the election by means of an election petition is neither common law nor fundamental right. It is a statutory right governed by the statutory provisions of the RP Act. Outside the statutory provisions, there is no right to dispute an election. The RP Act is a complete and self-contained code within which any rights claimed in relation to an election or an election dispute must be found. The provisions of Civil Procedure Code are applicable to the extent as permissible under Section 87 of the RP Act. It hardly needs to be reiterated that in an election petition, pleadings have to be precise, specific, and unambiguous. And if the election petition does not disclose the cause of action, it is liable to be dismissed in limine. It may also be noted that the cause of action in questioning the validity of election must relate to grounds specified in Section 100 of the RP Act, as well in Bhagwati Prasad and Rajiv Gandhi in such and such. If the allegations contained in the petition do not set out the grounds as contemplated by Section 100 and do not conform to the requirement of Section 81 and 83 of the Act, which I am submitting, they do not conform to Section 83 of the Act, the pleadings are liable to be struck off. Election petition is liable to be rejected under Order 7, Rule 11 CPC. A beneficial reference of the decision in the case of Lakshmi Narayan Nayak versus Ram Ratan Chaturvedi we also made, wherein this court, upon review of its earlier decision, laid down the following principles applicable to election cases involving corrupt practice. This court, in a catena of decisions, has laid down the principles as to the nature of pleadings in election cases, the sum of and substance of which being: the pleadings of the election petitioner in his petition should be absolutely precise and clear, containing all necessary details and particulars as required by law. Why such and such, such and such. The allegations in the election petition should not be vague, general in nature, or lacking of materials, or frivolous or vexatious, because the court is empowered at any stage of the proceedings to strike down or delete pleadings which are suffering from such vices as not raising any tribal issues by such and such, such and such. The evidence adduced in support of pleadings should be of such nature, leading to an irresistible conclusion of unimpeachable result that the allegations made has been committed, rendering the election void under Section 100. Why such and such. The evidence produced before the court in support of pleadings must be clear, cogent, satisfactory, credible, and positive, and also stand the test of strict and scrupulous scrutiny by such and such. It is an unsafe in an election case to accept oral evidence at the face value without looking for assurances for some surer circumstances or unimpeachable accounts by such and such. The honors of proof of the allegation made in the election petition undoubtedly on the person who assails an election, which has been concluded by such. The legal position with regard to non-compliance of requirement of Section 83(1) of the RP Act and the rejection of election petition under Order 7, Rule 11 CPC has been regurgitated recently by this court in the case of Kanimoi Karunanidhi versus Santana Kumar. The legal position enunciated in aforesaid states cases may be summed up as follows. Section 83(1)(a) of the RP Act 1951 mandates that an election petition shall contain a concise statement of materials on which the petitioner relies. If the material facts are not stated in an election petition, the same is liable to be dismissed on that ground alone, as the case will be covered by Clause A of Order 11 of Order 7 of the Court. The material facts must be such facts as would afford a basis for the allegations made in the petition and would constitute the cause of action. That is, every fact which would be necessary for the plaintiff petitioner to prove if transferred in order to support his right to judgment, omission of a single material fact would lead to an incomplete cause of action and the statement of claim would become bad. Material facts means the entire bundle of facts which would constitute a complete cause of action. Material facts will include positive statement of facts as well as positive averment of a negative fact, if necessary. In order to get the election declared void under Section 101(d)(4) of the RP Act, the election petition must ever, on account of non-compliance with the provision of the Constitution or Act, any rules made under, insofar as concerned was materially affected. The election petition is a new serious matter and it cannot be treated lightly or in a fanciful manner, nor is it given to a person who uses it as a handle for vexatious purposes. An election petition can be summarily dismissed on the omission of a single material fact leading to an incomplete cause of action or omission to contain a concise statement of material facts on which the petitioner relies for establishing a cause of action and exercise of powers under such and such and such. Bearing in mind the aforesaid legal position, let us consider the averments made by the respondent on such and such. As transferring from the election petition, respondent number 1, along with 13 candidates, including the present appellant, has submitted a nomination paper for such and such. However, according to respondent affidavit in forms 26 filed by the appellant, along with his nomination paper is invalid and defective, the same contain false statements and suppression and misrepresentation of facts with regard to educational qualification and suppression of facts with regard to liability in respect of loan availed by him by way of a cash credit for a partnership firm, namely MS Allied Concern, for which he was an active partner, and suppression of facts with regard to his default in deposit employers' contribution to the provident fund in regard of the employees of the said MS Allied Concern. As regard the false claim of election qualification as alleged in the election petition inter alia, the appellant had mentioned in column number 9 of his affidavit form the appended to his nomination of paper, the election code was Bachelor of Arts, which he has passed from Chaudhry Charan Singh University, Meerut, in Uttar Pradesh in the year 2019. But the appellant had never passed BA from the said university or from any other institution or university. It is further alleged in the election petition that the appellant did not mention about his so-called technical qualification of diploma in civil engineering in the nomination paper, which he had mentioned in the affidavit in Form 26 when he contested 2016 general election. The respondent number 1 also alleged that though the appellant was a partner in MS Allied Concern, which availed a loan from United Bank of India, Tarapur branch at Silchar, the appellant had deliberately suppressed the details of the CC limit loan account with the said bank and also the details made in the repayment of the said loan. The respondent number 1 has also alleged that the appellant had deliberately not mentioned about the liabilities of the appellant as a partner of the MS Allied Concern with regard to the employer's contribution to the provident fund for its employees. According to the respondent number 1, he had raised an objection before the returning officer on the date of scrutiny, that is on 5, and that the appellant did not possess the educational qualification of BA from Chaudhry Charan Singh University, and therefore his nomination paper was liable to be rejected. According to him, another independent candidate, such and such, had also raised an objection by submitting a written complaint dated before it. However, the returning officer had failed to exercise his jurisdiction and authority under Section 36 of the RP Act and refused to make even a summary inquiry by calling upon the appellant to meet the objection raised by him. Thus, according to respondent number 1, there was an improper acceptance of the nomination paper of the appellant. He also alleged that the misrepresentation and false representation of legal qualification of appellant in Form 26 and suppression of Mr. appellant in the said affidavit in respect of press facility and non-disclosure of the default of the appellant in respect of his liabilities towards the employer's contribution to the Provident Fund tantamounts to commission of corrupt practice of undue influence within the meaning of Section 132 of the RP Act. The respondent number 1 therefore has filed the election petition under Section 100. Section 100 of the Act seeking declaration that the election of the appellant returned candidate was void. The appellant, with the respondent number 1 election petition before the High Court, has submitted IA being number 2020, seeking rejection of election petition under Order 711 of the CPC, Radio Edition of the RP Act. It was contended by the allegation that the said application that the paragraphs alleging corrupt practice of undue influence on the election petition did not constitute material facts of alleged corrupt practices so as to give rise to a cause of action for filing the election petition. None of the statements made in the various paragraphs of the election petition could be said to be a concise statement of material facts or material particulars to give rise to a cause of action with tribal issues on falsity in nomination papers, improper acceptance of nomination paper, and commission of corrupt practice. Now, from a bare reading of the election petition, it emerges that respondent number 1 had made only bold and vague allegations in the election petition without stating the material facts in support thereof as required to be stated under Section 83(1)(a) of the RP Act. Apart from the fact that none of the allegations with regard to false statements and suppression of misstatements or material facts allegedly made by with regards to his educational qualification or with regard to his liability in respect of loan availed by him or for his partnership or with regard to his default in depositing the employer's contribution to the provident fund would fall within the definition of corrupt practice of undue influence.
Okay.
As
And
it's,
this was a case where the election, application under Order 7, Rule 11, same application was dismissed.
was dismissed by the Honorable High Court, was ultimately allowed by the Supreme Court.
Okay.
Paragraph 20 also, a few more paragraphs, but I'm basically relying on this.
It's okay, I've read it.
Now, paragraph 20, then my lord, kindly note regarding corrupt practice what the Honorable Supreme Court is saying. Respondent number was required to make concise statements of material fact as to how the appellant had indulged in the corrupt practice of undue influence by directly or indirectly interfering or attempted to interfere with the free exercise of the electoral rights. These statements are not there in the election petition.
Yes.
And regarding one improper, I'm relying on all the paragraphs, my lord, right up from 11 to my lord 23. 23, I will just read when the lordship permits. This is regarding improper acceptance. As transpiring from the election petition, the respondent number 1 himself had not raised any objection writing as a nomination. According to him, he had raised an oral objection. It would, if he could make oral objection, he could very well make a writing. Even if it is accepted that he had raised an oral objection with regard to the educational qualification of the appellant before the returning officer at the time of scrutiny, the respondent number 1 has failed to make averment in the election petition as to how the appellant's nomination was liable to be rejected by the returning officer on the grounds mentioned in Section 36(2) of the Act. Not here in this case also. As to make his case fall under clause D1 of Section 101, that there was improper acceptance of the nomination of the appellant. The non-mentioning of the particulars as to how such improper acceptance of nomination had materially affected the result of the election is apparent on the face of the election petition. This is not there in this election petition also. As to how the improper acceptance of the nomination of the returned candidate has materially affected the result of the election so far as the returned candidate is concerned. These are all on similar lines, Karikokri, the election petitioner's case, my lord. 2024 SCC online SC 519. These are also very longish paragraphs, my lord. I am relying from paragraph 20 to paragraph 50, my lord.
Almost same thing.
Huh?
There are 20 to 50.
50, my lord. Because my lord will kindly note that his prayer for declaring the election void is in just a moment. All the paragraphs have been invoked over section 100. Just a moment. Okay. Except for my lord, 100. A, C, and my lord, 100D3, all the provisions have been invoked. Now, 104 also, we will have to show as to how it is materially affected. There is no pleadings to that effect also. So I'm not bothering on lordships with this, my lord. Paragraph 20 to 50, my lord. Improper acceptance, my lord. Paragraph 36, I will just read again. In Marembam Prithviraj, corrupt practice, my lord, is in, my lord, there is no paragraphs. This court has noted that there is a difference between improper acceptance of the nomination of a returned candidate as opposed to improper acceptance of a nominated other candidate. It was observed that mere finding that there was an improper acceptance of a nomination would not be sufficient for a declaration that the election is void under section 101D1. And there has to be further pleading and proof that the result of the election of the returned candidate was materially affected, but there would be no necessity of any proof in the event of nomination being declared as having improper acceptance, especially in case where there are only two candidates in the fray.
Yes.
Facts are similar to this. I am relying from paragraph 12, because here also, my lord, the election petitioner here, he was a returned candidate then. Did not declare his the Ford scooties. Then he did not declare his, my lord, Bangalore. All these things are there. That's all, my lord, sum and substance, my lord. That is the case, my lord. So far as the undue influence is concerned, there is no pleading to the effect. As far as undue influence is concerned, my lord, there will have to be, my lord, ever been the election petition as to how, my lord, the result of the election has been materially affected so far as the election petition is concerned. That is not there. There is nowhere there, my lord. In fact, my lord, the pleadings will see this, all these objections they have raised that were not raised at the time of the scrutiny of the nomination paper. So there was no question, my lord. There was no occasion for the, my lord. There's no occasion for any improper acceptance, because the paragraph itself reveals that it was filed only after, my lord, the scrutiny was done. And corrupt practice, my lord, no, there will have to be, my lord, concise statements, my lord, stating specific and precise facts as to how that corrupt practice was done. Absolutely nothing is there, my lord. There are only 4 paragraphs, my lord, has seen. Absolutely nothing. No name, nothing, no time, nothing. I will not bother lordships, but I'm just giving the citations. On improper acceptance, there is another one, my lord. 2012-11 SCC.
Yes.
390. Paragraph 13 to 20.
Improper acceptance.
Improper acceptance. I'm just, yes. Paragraph 13 to 20. One paragraph, my lord, I would like to.
Just wait. Yes. Later will you be here? Yes. Yes.
My lord, I'm relying on paragraph 13 to 20. Your lordship may kindly have paragraph 15 for a moment.
Shambhu Prasad.
Yes.
Para
15. I'm relying on 13 to 20, my lord. I'm just reading the 2 paragraphs.
Suffice to say.
Suffice it to say that the case pleaded by the appellant was not one of complete failure of the requirement of filing an affidavit in terms of the judgment of this court and the instructions given by the Election Commission, but a case where even according to the appellant, the affidavits were not in the required format. What is significant is that the election petition did not make any averment, leave alone disclose material facts in that regard, suggesting that there was indeed any outstanding dues payable to any financial institution of the government by the returned candidate or any other candidate whose nomination papers were accepted. Same case here that I was pointing out earlier occasion also. There is no assertion made. The objection raised by the applicant was thus in the nature of an objection to form rather than substance to affidavit, especially because it is not disputed that the affidavit filed showed the outstandings to be nil. What am I required to show in the Form 26? Whether I have availed any government accommodation, and if so, whether I have dues or not. So there is no assertion, my lord. And paragraph 20, my lord, just a moment.
Paragraph 20.
20.
Yes.
Coming to the allegation that other candidates has also not submitted affidavit for rendering the acceptance of their nomination papers improper, we need to point out that the applicant was required to not only allege material facts relevant to such improper acceptance, but further assert that the election of the returned candidate had been materially affected by such acceptance. That is not averred. There is no such assertion in the election petition. Mere improper acceptance, assuming that any such improper acceptance was supported, was just a moment. Acceptance was supported by assertion of material facts by the appellant petitioner, would not disclose a cause of action to call for trial of the election petition on merit unless the same is alleged to have materially affected the result of the returned candidate. That averment is not there. So far as, my lord, paragraph 19 and subparagraphs are concerned, there is no averment as to how this alleged improper acceptance has materially affected the result of the election so far as the returned candidate is concerned. Instead of four judgments have been substance manner. The others were same thing has been manner. So I am not. So that is my humble submission, manner. The improper acceptance, manner, the judgment of the there is nothing, no environment with that effect. And as far as corrupt practice is concerned, it is as vague as it can get. It is as vague as it can get. There is no statement. So this is the corrupt practice. This is the person who have been bribed. This is what has happened. Nothing is there. So in the absence of that, my lord, I cannot be made to undergo a trial, my lord. It's a case, fit case, my lord, whether lordship will exercise his powers under 711, and my lord reject the plan and election petition. No problem.
May I please, your lordship?
Yes.
Lordship, this instant election petition has been filed on the ground of corrupt practice of undue influence, lordship, to declare the election to 44 Teju ST Assembly constituency void in respect of returned candidate under section 98 subsection C of RP Act on the ground stipulated under section 101B, 101D, Roman 1 and section 100 subsection 1D Roman 2 and section 100 subsection 1D Roman 4, and to further declare the election petitioner elected on the ground under section 100B. Lordship,
Before for a moment, there's another.
Lordship, before moving towards the ground, basically, Lordship, this election petition has been filed under section 123. Under section 123 of the Act, which basically talks about corrupt practice of undue influence. So may I take your lordship to, since my senior here has already read out, however, I won't bother much, lordship. I just want to point out certain, under what provision this instant election petition has been filed. May I read, lordship? Section 123, corrupt practice. The following shall be deemed to be corrupt practice for the purpose of this Act. Section 123, subsection 2. As I have already stated, lordship, as I have already submitted, this election petition has been filed on the ground of corrupt practice under section 123. So basically, I'll be on a ground, this
Subsection
election.
2 only.
Yes.
Undue influence.
Undue influence, Lordship.
Yes.
Corrupt practice of undue.
No, you are not on other. Not
Yeah, so
subsection 1.
apart from other ground that I'll come, since this issue was raised by the applicant, Lordship. Undue influence, that is to say, any direct or indirect interference or attempt to interfere on the part of the candidate or his agent, on the part of the candidate or his agent, Lordship may mark this, or his agent, or any other person with the consent of the candidate or his election agent with the free exercise of any electoral right, provided that without prejudice to the generality of the provision of this clause, any such person as is referred to therein who threatens any candidate or any elector or any person in whom candidate or any elector interested with injury or any kind, including social ostracism or excommunication or expulsion from any caste or community. Lordship may mark this this particular line also, Lordship, since this has been alleged in the election petition, Lordship. Second, induces or attempt to induce a candidate or any elector to believe that he or any person in whom he is interested will become or will be rendered an object of divine displeasure or spiritual censure. I'm not onto this. A declaration of public policy or promise of publication or the mere exercise of legal right without intent to interfere with electoral right shall not be deemed to be interference within the meaning of this clause. The appeal by candidate or his agent or by any other person with the consent of the candidate or his election agent to vote or refrain from voting for any person on the ground of his religion, race, caste, community, or language, or the use of or appeal to religious symbol, or the use of or appeal to national symbols such as national flag or national emblem for the furtherance of the prospect of the election that the candidate or for prejudicially affecting the election of any candidate.
Is not your case.
Yes, sir.
Yes, Lordship.
This is related to
No, you have to read whole appeal by candidate or which is by any other person with the
Yes.
consent of the candidate or his religion to vote or refrain from voting person on the ground of his religion. Raise cost by gesture or by sign to vote for the return candidates or
yes, Lordship. Yes.
subsection 2.
Yes. Now,
1. No, it's not subsection.
yes, even yes, bribery also, Lordship. Any gift offer or promised by candidate or his agent or by any other person with the consent of the candidate or his election agent of any gratification to any person whomsoever with the object directly or indirectly of inducing a person to stand or not
Which
to
one?
stand. Lordship, this 123 subsection 2. Gift offer or promise is also there, Lordship. And Lordship, section 100, Lordship.
Maybe 120, 123, 2, not the 3, not subsection 3, which you have read.
Yeah,
Isn't
no,
it?
no, Lordship. Not subsection 3.
You are only on subsection 2.
Yes, and if I'll come to that, Lordship. The election petition, it also covers subsection 1 also, Lordship. And Lordship, on the grounds under section 100, Lordship, that any corrupt practice has been committed by return candidate or his agent or by any other person with the consent of the return candidate of his or his election agent, that any nomination the Lordship, the result of the election insofar as it concerns a return candidate has been materially affected by the improper acceptance or any nomination by corrupt practice committed in the interest of the return candidate by any by an agent other than his election agent or by non-compliance with the provision of Constitution or of this Act or any rules or orders made under this Act, Lordship. Now, if I may take your Lordship to Section 83, Lordship, which has already been read out. Section 83, Lordship, it talks about contents of the petition, Lordship. Now, Section 83, may I read, Lordship? Section 83, an election petition shall contain a concise statement of material facts on which the petitioner relies.
110 subsection D, clause D, subsection clause D.
Yes, Lordship.
Improper acceptance of or any nomination. Huh? Any corrupt practice, improper reception, refusal, rejection, of any vote or reception.
Not 3, but 4, Lordship. Roman 4.
Huh. 1 also. Roman 1.
Yes, Roman.
Close the Roman 1.
Yes, close the Roman
and
1.
Roman
2.
2 and 4.
4, Lordship.
Hmm?
Yes, Lordship.
Yes.
Now, Section 83 talks about concise statement of material facts on which the petitioner relies. And B shall set forth full particulars of any corrupt practice that the petitioner alleges, including as full statement as possible of the names of the parties alleged to have committed such corrupt practice and the date and place of commission of each such practice. And next is shall be signed by the petitioner. Now, Lordship, with regards to the application filed by the returned candidate, Lordship, this application has been filed basically stating basically that the election petitioner has not disclosed material particulars with regards to paragraph 19 only, Lordship. Now it has quoted all the paragraphs contents of paragraph 19, Lordship. Nowhere it has mentioned paragraph 20, Lordship. Now, although paragraph 20 has not been mentioned, may I take your Lordship to page 25, Lordship. This pertains to paragraph 19, subparagraph 1 to 6, Lordship.
Page election petition.
Yes, of the election petition, Lordship.
Page
25 to 44.
That we have seen. '25.
Yes, Lordship.
Election petition.
Yes, Lordship. 25.
Yeah, he has read it.
I won't bother Lordship by reading out each and every paragraph. However, Lordship.
No, you may, you can.
Lordship.
He has read out and said that there is no cause of action not to talk about full particulars.
Yes, Lordship.
By reading it out. You read it out and say that there is a cause of action and the material particulars have been
yes, Lordship.
pleaded.
Yeah, before going through this, Lordship, material facts and particulars with regards to corrupt practice of undue influence. And here, if your Lordship may...
No, 19 is, although you have said material facts with regards to corrupt practice, undue influence,
no,
this is basically of Form 26.
Yes.
False
yes.
declaration or
yes, Lordship.
false statement
Yes, Lordship.
in Form 26.
Non-disclosure of assets. Yes, Lordship. Now, before Lordship, before going through this, Lordship, we have to, Lordship, we have to understand what is material facts and particulars. In all the cases that has been cited by the applicant, Lordship.
Do you think that this code is not, doesn't understand what is material facts?
No,
and what is
Lordship,
material
just
particulars?
I want to point it out, Lordship, before all those case laws, Lordship, that has been relied by the applicant, Lordship. This talks about material facts only, Lordship. Material facts, nowhere in all the cases, it has not said that this election petition has been,
No, you saw first and come to the judgment.
yes, Lordship. I just want to point out, Lordship, this
Yes, yes.
material facts, Lordship is aware that material facts are the basic facts on which the election petitioner, as far this so far this election petition is concerned, election petitioner is relying, and material particulars are the details of the material facts, Lordship. Now, if your Lordship may kindly see para 19, Lordship. Para 19. Here, Lordship, para 19 sub para 1, Roman 1. May I read, Lordship?
Yes, yes.
That it is mentioned in note 2 of para 7B of Form 26 that each land or building or apartment should be mentioned separately in this format. However, returned candidate had not only committed an apparent error in numbering the paragraph, but also made a false declaration by not disclosing the complete information with regards to the said paragraph. The returned candidate in his Form 26 affidavit has incorporated subparagraph A twice instead of subparagraph B in paragraph 7, which deals with details of immovable assets. Further, returned candidate in paragraph 7B, serial number 4 of his Form 26 affidavit had failed to disclose his residential flat measuring so-and-so on the 4th floor of so-and-so building at so-and-so under Dispute Revenue Circle, Kamrup, Assam. The information of which the election petitioner has obtained from the authority concerned. Such non-disclosure of property worth so-and-so during the time of the purchase for which returned candidate has paid such and such duty is defect of substantial nature which has materially affected the result of the election. Lordship, by saying this, Lordship, this material facts, Lordship, with regards to non-disclosure has already been mentioned. Now, coming to material particulars, has been given, Lordship, that this particular building has not been.
How it has materially affected. Saying that it has materially affected will not be suffice, will not be enough.
Yes, Lordship.
How non-disclosure of this asset,
Lordship,
under Form 26 has materially affected the election of the returned candidate.
Lordship is aware that in Resurgence India case, Lordship, there the basic question was whether particular voters have the right to know their candidate or not. That basic issue was raised. In that case, Lordship, although I'll be relying on certain paragraph.
Yes, no issue.
You'll
have to show in your pleading.
Yes, Lordship.
That these material facts, non-closure, these facts, suppose it's a non-false declaration, non-disclosure in the Form 26, how it has materially affected. You'll have to show that.
Lordship,
you have to avert that.
Yes, Lordship, that those non-disclosure has been mentioned.
It's okay, you have to, you said is a defect of substance which has materially affected. How? You have said, no doubt, that it has materially affected the result of the election.
Lordship, here in this particular paragraph, it has not been said, but saying that this particular non-disclosure.
You have to show.
Lordship.
That is called the full material facts and full particulars.
Lordship, this is basically pertains to the improper acceptance.
That's what
although these things,
improper acceptance
that has been brought to the notice of the returning officer. And to this aspect, Lordship, page 331, Lordship. The petitioner, election petitioner, he was aware of all this. He has filed a complaint before the returning officer by affidavit, Lordship. Affidavit dated 28 March 2024. All those, sharing all those information that this particulars has not been disclosed. So, because of and prayed to the returning officer to reject the nomination paper of the election petitioner on the ground of non-disclosure. So,
After the scrutiny.
No, Lordship. This, may I take Lordship to page 331 of my election petition,
On
Lordship.
the day of scrutiny.
Yes, Lordship. 331. It starts from documents 19, Lordship.
330.
1 to 336. May I read, Lordship? Relevant Lordship, relevant pages with regards to this particular amendment is page 335, Lordship. Para 13. That it has come to knowledge of the deponent that the candidate concerned has a property beyond the state of Arunachal Pradesh, which has not even been disclosed by the candidate concerned, and which property to the knowledge of the deponent continues to be with the candidate. The same is evident from a perusal of the Indian non-judicial.
When was the scrutiny?
Yes, Lordship.
Scrutiny?
28 March, Lordship.
28.
Okay.
28 March. It is in paragraph.
That's correct, 28 months.
Okay. Yes.
Lordship, basically, Lordship, what I meant to say is these particular issue were brought before the returning officer during the time of scrutiny, and all those averment are being substantiated by as many as, Lordship, as many as 39 documents, Lordship, including this particular averment. So through these documents, the election petitioner can show that this particular issues was had substantially and materially affected the result of the election. Had this particular affidavit been considered, the return candidate would not have been qualified to contest in the election itself. So that this was brought before the returning officer, Lordship. So, and regarding this issue, this was already brought up. And regarding next, Lordship, this is related to related to certain government accommodation availed by the return candidate, Lordship. Even with regards to this, although there is a specific environment that the petitioner has obtained through RTI, that it has obtained the information through RTI that has been made specifically pleaded in this. However, from this environment, the applicant has said that this particular things was brought up only after the election result was declared or election was over. However, even this knowledge, Lordship, even this has been included in the affidavit that has been filed on dated 28/3/2024 during the time of scrutiny of the nomination, Lordship. Now, this RTI application was filed, although information was there. However, Lordship, to adduce these documents as in the form of evidence before this honorable court during the course of trial, that documents has to be either be the original or the certified copy of the same, Lordship. So even the non-disclosure, by not disclosing the government accommodation, the return candidate has made a false picture of himself before the competent authority, and even that amounts to perjury, Lordship. That has been specifically all those has been specifically pleaded that this particular bungalow was not has not been disclosed in the Form 26 affidavit, Lordship. And no due certificate pertaining to that bungalow has also not been disclosed. And then in fact, the same has presented a false picture of return candidate, and which in fact, Lordship, that has materially affected the result of the election, Lordship. And paragraph with regards to para 19 sub para 4, Lordship, this talks about the information pertaining to details of movable and details of immovable assets, which has to be mandatorily disclosed by the contesting candidate, Lordship. And this is this particular paragraph is pertaining to the spouse number 1 of return candidate. Now, as per this paragraph, if the return candidate, as Your Honor, Your Lordship has rightly pointed out, in fact, it is not within it is not the case that the return candidate is not aware of the asset and liability of the spouse number 1, which the return candidate has already filed in Form 26 affidavit of 2019 election. So those information could have been incorporated. Lordship, not known as spouse number 1, has declined to share any information to me due to our estranged relationship because of my marriage with spouse number 2 won't mitigate, Lordship, because it has to be the contesting candidate has to mandatorily disclose all the non-information, Lordship. So this, because of this non-disclosure, Lordship, it has presented a false picture that averment has been made before the voters. So that has materially affected the result of the election, Lordship. Now, with regards to all the bank account details, everything that has been specifically mentioned, Lordship. And in fact, in page 37, the election petitioner has made a specific averment that by non-disclosure thereof, the respondent number 1 has made false statements and give false declaration in Form 26 affidavit dated 27/3/2024, submitted his nomination paper for the election to 44 Teju ST Assembly constituency. It is a corrupt practice as mandated under Section 123 of the RPA. The election that has been specifically pleaded. And then with regards to subpara 4, Lordship, certain vehicles has not been mentioned in the Form 26 affidavit, although it has been already certain aspect of it has been covered in the previous in certain cases, Lordship. And this, by non-disclosure of this, Lordship, it has, as I have already submitted, Lordship, it has presented a false picture before the voters. And in fact, it has not, by doing that, it has not disclosed the full particulars of the election of assets and liabilities. And para 4 is with regards to respondent number 2. And may I take, Lordship, to page 44, Lordship. This is also connected to material facts and particulars of corrupt practice of undue influence committed by respondent number 1. May I read, Lordship? The respondent number 1 return candidate has engaged his man, agent, and supporter to distribute election previes and money to the voters of 44 Teju ST Assembly constituency, more particularly Jeko village. In one such instance, Sri Thompson Boje, who was the supporter and polling agent of return candidate of 31 Jeko village. Lordship may mark this. He was not only the supporter, but he was the polling agent, Lordship. Polling agent of the return candidate of 31 Jeko village was found to be indulged in distributing money at the behest of the return candidate. As a result, the petitioner secured fewer numbers of votes from Jeko village. That is evident from the numbers of votes that has been secured by the election petitioner, Lordship. Further, sector magistrate, along with the flying squad and Arunachal Pradesh police, had seized an amount of rupees 17 lakhs 10,000 from Thompson Boje, who was carrying the said amount in vehicle number so and so at around 12:30 p.m. on 17/4/2024 at Teju. One of such supporters from Jeko village who had voted for the return candidate has informed the election petitioner that had he not received certain sum of money from Thomson Boje at the behest of the return candidate, he would not have voted for the return candidate. This lordship, this particular paragraphs, averment has been made on the basis of the information shared by the voters of the Jeko village, lordship. Now the issue is we have filed certain list of witness. So some of them will, lordship, will substantiate those statements, lordship. So it has not come to that stage. But here it has been specifically pleaded. In fact, one of the police officer who has in fact quote this Thomson Boje on 17/4/2024, he has also been subpoenaed as witness in the instant case, lordship. So all those these are the corrupt practice within the meaning of the relevant provisions of this act, lordship, of the RP Act, lordship. Now, hence the above mentioned corrupt practice of undue influence committed by the return candidate in connivance with his polling agent, Sri Thomson Boje, has materially affected the result of the election in question, lordship. Now, with regards to para 20 sub para 2, lordship, here Sri Sokep Kri, who is working as State Gazetteer, Government of Arunachal Pradesh, and Director, Department of Indigenous Affairs, Government of Arunachal Pradesh, at the behest of the return candidate, had held a press conference through local news channel, namely Divinity Jagran, on 17/4/2024, where he has leveled serious allegation against the petitioner and his son's involvement in official raid undertaken by the Flying Scout team and Arunachal Pradesh Police in his residence at Teju on 16/4/2024. The said person, who is also the brother-in-law, lordship, Sokep Kri is the brother-in-law of the return candidate. So even if, since we have brought that issue before this honorable court, it is obvious that there is a connivance, lordship. The said person, who is also the brother-in-law of the return candidate, went on to blame the petitioner for such official raid undertaken by the authorities concerned. As such, the petitioner, being a law-abiding citizen, has sought clarification from the district election officer Lohit whether he has any involvement in the said raid as alleged by Sri Sokep Kri. It is pertinent to mention here that many such official raids took place at 44 Teju ST Assembly constituency, which includes the house of the supporters of the petitioner, namely Sri Ampelu Chokwa at Tamlanagar and Sri Akai Toang at ANC line Teju. However, neither the petitioner nor any of his main agent and supporter had raised any question against the official concerned or tried to defame any contesting candidate. Hence, it is crystal clear that Sri Sokep Kri had intentionally held the press conference at the behest of his brother-in-law, Dr. Mohet Chai, thereby disregarding his avowed duty to public as a public servant in the capacity of Director, Department of Indigenous Affairs, Government of Arunachal Pradesh. While doing so, Sri Sokep Kri had called the petitioner a criminal, virus, dangerous for civil society and communal harmony, and appealed to the voters of the said constituency not to vote for the petitioner in furtherance of strengthening the winning prospect of return candidate. As a result, he had influenced the Mismi community in voting against the election petitioner, lordship. Being agreed by the same, the petitioner made representation dated so-and-so to the Chief Election Commissioner of India, the Chief Secretary, Government of Arunachal Pradesh, and District Election Officer Teju, respectively seeking action thereof. However, the same has not been considered by the authority concerned. As a result, it has materially affected the result of the election in question. The aforesaid incident of corrupt practice of undue influence committed by the return candidate in connivance with his brother-in-law, Sri Sokep Kri, was captured by video recording of Divinity Jagran news channel and are in public domain, which, with the leave of this court, the election petitioner would submit in pen drive at the stage of production of documents during the course of trial. Lordship, although at the moment I do not have the case law with me, however, with regards to this particular issue, where there is involvement of government servant, lordship, there it is a clear ground of corrupt practice, lordship. And since considering that this particular person who has held the press conference blaming the election petitioner that all those flying squad has raided his place, and then he has in fact discouraged, or he has appealed to the public to not to vote a person with such criminal background and who is in fact virus for the society. So that has substantially, although by combined reading of this Everman, it clearly made out the case that this, because of the illegal act committed by brother-in-law of the returned candidate, it has materially affected the result of the election, Lordship. Now, with regards to para 4, Lordship, I don't want to bother you on this particular para, since this has not been met as a part of the issue in the issue that has been, in fact, framed by this honorable court, Lordship. I'll confine myself to the issues which has been.
Issue has not been framed.
Lordship, issues has been framed.
Yes,
Yes, it was. It was framed on 7/1. Now, these are this pertains to the one of the relatives of a nephew of the returned candidate who was present in the polling station number 15 that has been mentioned of polling station number 15, Government Higher Secondary School number 2, Tamla Nagar. So the particulars of that person has been given, and in fact, the relation of that with the returned candidate, that has also been clearly mentioned. And these particulars has been given since although election petitioner was not physically present there, but he has been informed that this person who was in polling booth number 15, by gesture or sign, he has discouraged the voter to not to vote again, since there are many numbers of Lordship, non-local voters. So this pleading has been incorporated, and there is in para 4, Lordship, there were instances of double casting, and that has been of double casting of ETPBS electronically transmitted postal ballot system. So that has been mentioned, and then to that respect, to substantiate that, certain many documents has been incorporated in the election petition itself. And with regards to paragraph 5, Lordship, this is in connection to polling booth number 3, Tapragam, and polling booth number 7, Government Higher Secondary School, Teju, and polling booth number 12, Government Primary School, ALC Line, polling booth number 15, Government Higher Secondary School number 2, Tamla Nagar, where there was where certain some votes could not be some voters could not cast their vote, and here, Lordship, I have made specific awareness that few of the voters who could not cast their votes informed the same to the petitioner, and in pursuant thereto, petitioner has brought to the notice of the authority concerned of the said incident, white letter dated so and so. The same has not been considered by the concerned authority, and later on, it was found that there was mismatch of certain votes, Lordship. So, and with regards to that, Lordship, many complaints were made before the competent authority, and that has also been not considered, Lordship. Now, basically, had there been no corrupt practice, Lordship, these numbers of just applicant has submitted the 2,805 voters, the return candidate could not have won by this much margin. So basically, Lordship,
how much margin he would have won? If it is not done, not this much margin, 2,800.
Lordship, had it not been for
2,800.
Yes, Lordship.
That is the margin.
For this corrupt practice.
By a margin of 2,800.
Lordship. So
he has won.
Yes, Lordship.
So if it is not there, how much
no
margin he would have?
Then, Lordship, the election petitioner has
1,000.
won the election.
Even if one by one margin also,
Lordship.
Exactly, there is not there.
Yes.
So
you have to show that even this
Lordship,
not even a single margin. This should have been in your favor. You should have.
Lordship, the sum and substance of this paragraph 19 and paragraph 20 would goes on to show that had there not been improper acceptance of nomination paper and had there not been corrupt practice, Lordship, the election petitioner could have won the election, Lordship.
By how much margin?
Lordship, by any margin, Lordship. Now, Lordship, since this particular election petition, Lordship, since I pointed out that some material facts has been clearly stated in the pleading, Lordship, and at the same time, although some of the pleadings, for example, here in paragraph 5, Lordship, paragraph 5, subparagraph 5 of para 20, Lordship, here some specific particulars has not been given, but in other paragraphs, the election petitioner has specified.
Which paragraph?
No.
Which other paragraph?
No, in all the paragraphs, Lordship.
Which all the paragraphs?
Paragraph 19, subparagraph 1 to 4, and paragraph 20, subparagraph 1 to para 5. So here, election petitioner has specifically pleaded the material facts as well as the material particulars, Lordship. And with regards to this, Lordship, I would like to rely on the judgment of Honorable FX Court, 2005-13 SCC 511. 2005-13 SCC 511. Relevant paras are 46, 47, 48, 51, 52, 82, and 83, Lordship. So I'll take Lordship to page para 51, Lordship. May I read, Lordship?
Yes.
A distinction between material facts and particulars, however, must not be overlooked. Material facts are primary or basic facts which must be pleaded by the plaintiff or by the defendant in support of the case set up by him either to prove his cause of action or defense. Particulars, on the other hand, are details in support of material facts pleaded by the party. They amplify, refine, and embellish material facts by giving distinctive touch to the basic contours of the picture already drawn so as to make it full, more clear, and more informative. Particulars thus ensure conduct of fair trial and would not take the opposite party by surprise. All material facts must be pleaded by the party in support of the case set up by him. Since the object, all material facts, Lordship here. Since the object and purpose is to establish the opposite party to know the case he has to meet with. In the absence of the pleading, a party cannot be allowed to lead evidence. Failure to state even a single material facts, hence, will entail dismissal of the suit or petition, Lordship. Material facts here. Particulars, on the other hand, are the details of the case, which is in the nature of evidence, Lordship, as party would be leading at the time of trial, Lordship. Now, material facts in the instant election petition, material facts has been clearly set out, Lordship. Yes, the return candidate has not disclosed the details of movable and immovable asset of his spouse number 1, spouse number 2, and there is a false declaration with regards to availing of government quarters. So all this in paragraph 19(1) and paragraph 19 and paragraph 20, it has been clearly set out, Lordship. Now, may I take Lordship to para 53, Lordship. The function of the particulars is to carry into operation the overriding principle that the litigation between the parties and particularly the trial should be conducted fairly, openly, and without surprises, and incidentally to reduce cost. This function has been variously stated, namely either to limit the generality of the allegations in the pleading or to define the issues which had to be tried, for which discovery is required. Each party is entitled to know the case that is intended to be made against him at the trial and to have such particulars of his opponent's case as will prevent him from being taken by surprise. Particulars enable the other party to decide what evidence he ought to be prepared with and to prepare for the trial. A party is bound by the facts included in the particulars, and he may not rely on any other facts at the trial without obtaining the leave of the court. Lordship, since in the instant election petition, all those material facts and particulars has been clearly set out, Lordship. And in fact, Lordship, it is not the case that the returned candidate are not aware of what allegation has been leveled, Lordship. So basically, it won't take them by surprise, Lordship. Now, may I take Lordship to page para 82, Lordship? May I read, Lordship? As we have already observed earlier, in the present case, material facts of corrupt practice said to have been adopted by the respondent had been set out in the petition with full particulars. It has been expressly stated as to how Mr. So-and-so, who was a gazetted officer of so-and-so in the government of public, assisted the respondent by doing several acts, as to complaints made against him by authorities and taking of disciplinary action. It has also been stated as to how police officer who was holding the post of so-and-so helped the respondent by organizing a meeting and by distributing posters. It was also alleged that correct and proper accounts of election expenses has not been maintained by the respondent, though at the time of hearing of the appeal, allegation as to projecting himself as Maharaja so-and-so by the respondent has not been pressed by the learned counsel for the appellant. Full particulars have been set out in the election petition in respect of other allegation. The High Court, in our opinion, was wholly unjustified in entering into the correctness or otherwise of the facts stated and allegation made in the election petition, and in rejecting the petition, holding that it did not state material facts, thus did not disclose a cause of action. The High Court, in our considered view, stepped into the prohibited area of appreciating the evidence, and by entering into merit of the case, which would be permissible only at the stage of trial of the election petition and not at the stage of consideration whether the election petition was maintainable, Lordship. Now, the election petitioner has clearly set forth the material facts and particulars. As I have already submitted that it is not the case that where the respondent are not informed of what case has been alleged against them, Lordship. Next, please. Next, Lordship. Lordship, it is connected, it is Resurgence India versus Election Commission of India. 2014 SSC 189, Lordship. Lordship, paragraph 2, Lordship. This is the background.
Okay, background notice.
And para 29, Lordship. May I read, Lordship? Background. This is basically with regards to improper acceptance of nomination paper, where the return candidate has failed to disclose the correct information, Lordship. In order to maintain the purity of election and to bring transparency in the process of election. Yes, para 2, background, Lordship. Paragraph 2.
We'll continue. When? Tomorrow, day after.
Lordship, I'm not keeping. So,
that's what I'm saying.
Can it be after a week, Lordship?
No, we'll hear this week only.
Yeah.
Almost, you have completed, almost you have completed.
Lordship, I'll be relying on.
Let us do one thing. We'll fix it on Friday, right?
Lord,
Friday or next week?
Lordship, can it be on Friday, Lordship? Next week, Lordship. We will.
Then make it Monday. Monday.
Yes, Lordship.
And it
On the
should
16th.
be heard at the last of the, I mean, after all the list. huh?
Yes.
Then Lordship, can it be on?
Or before just the hearing matters.
Yeah, just for it.
Lordship, can it be on 17 then?
17 is what?
Tuesday, Lordship.
Tuesday, they always.
I'm not keeping you and so. I don't know.
So that day, you come up with the written submissions. Written submission.
Written
And
submission.
you, along with that, you complete your argument.
Lordship, otherwise, it is covered in the. Yes.
You come up with the written submission.
Okay.
It's because order will be reserved. So it means it's convenient for me to
Lordship.
have your submissions already on the book.
Lordship.
17, huh?
17.
Heard Mr. D. Pangi, Land Council for the applicant public. Respondent. We just read applicant in the IA 71 and Mr. A. Thatak, Land Council for the opposite party only election petition. Hearing of the introductory application remains inconclusive. Hearing to continue on 17th. Hearing to continue. Mr. Age agreed to well and council for the parties list on 17/06/2020. Will not record that, but you, both of you submit your written argument. Okay.
Deeply over.
We'll complete on that day.
Lordship.
Provided you are keeping, if you are.
Yes. Certain judgments. Yeah, मेरा एक है.
IA 71.
This item number 42 and 43 may be listed after 2 weeks. My senior
What is there?
has to leave this honor of due to some personal difficulties.
What is there? Nothing. Who is for the private respondent?
Gitalo,
Huh?
Gitalo, Your Lordship, Galentalo. Gitalo is representing respondent number 2, Your
Yeah,
Lordship.
where is? Bengia Jayanta.
Yes, Your Lordship.
Where is? We'll dispose it today. What's there?
Mr. R. the standing counsel for the information commission.
So it is listed for hearing. Court is sitting.
He was here in this morning, but due to some personal difficulty, he has to leave. He is now out of station.
Where is this?
Humbly pray that this item number 42 and 43 may be listed after 2 weeks.
42 can be fixed next week, Your Lordship, in that case, Your Lordship.
Yeah, that can be. 42 can be fixed after a week.
This can be disposed of, Your Lordship, next week.
Next week, you'll receive item number 42.
No, all the case cannot be fixed like that, no. Unless there is so, I mean, unavoidable, it is fixed for today. Tomorrow, next week will be, there is so many cases again. Not next week, Thursday. Thursday. It's prayed for by London, no, MS, A and U.
And
And
Anju.
then counsel for the petitioner. Next prayer. On the prayer of Mr. Ibam, learned counsel appearing on behalf of Mr. RCK, learned counsel for the respondent, for respondent number one.
Yes, Your Lordship.
Respondent number one. Comma, APIC, APCA, APIC, Arunachal Pradesh Information Commission. On the ground that Mr. Seki, Land Council had to leave the court premises due to personal difficulty. This, the matter on, when is the Thursday? Well, 06/20/25. Whatever this respondent,
Respondent number 2 is represented by G. Talo, Your Lordship.
you inform.
Yes, Your
Huh?
Lordship. Yes.
Non-represent, non-appears for respondent number 2. Huh? Inform.
Yes, Your Lordship.
Detail.
Obliged.
Will not adjourn this on this. Will not adjourn the matter
Okay, I'll inform.
on a Thursday. Yes.
Your Lordship, I have taken the consent from the council for the opposite side. Your Lordship. This matter may be listed after 2 weeks. Your Lordship. I have already informed the other side.
This before any other appropriate bench without me.
Much of that.
Not before me. Yes.
May I pray, Lordship? Lordship, today I am praying for to dispose of this matter. The
What is
matter
to be
relates.
disposed of? Dismiss. What is there? You went to Supreme Court. Supreme Court has just.
No, Lordship,
on
I
the
have very
basis of
limited prayer, very
What-
limited
what
prayer on the
limited?
basis of the affidavit filed by the respondent number 3. They are agreed that once the project is completed, we will be given the first preference.
Huh?
Once the project, which is constructing at the Papu Hill, our quarter, we have already vacated and the construction
You
is
have
going.
already vacated.
Yes.
The matter ends
And,
there.
and Lordship, they have filed in the affidavit that once this project is completed, we will be given the first preference to
Where it
accommodate
is?
there.
Where it is?
Lordship, in the affidavit filed by the respondent number 3,
Who is respondent number 3?
UD and Housing Department. They are the confident authority. Page number 7, para 16. In the affidavit.
Yes.
Page number 7, para 16. Lordship, if we count from the bottom line, 10. From the bottom line, if we towards
Yes.
outside. Secondly, the petitioner of this case can, Lordship God. Secondly,
Yes.
the petitioner of this case can be re-accommodated immediately on completion of project, whereas project affected peoples of East Sector Nagaland have no such advantage. After the lapse of 1 year, they may have to seek SRA and arrange their own accommodation. If no alternate regular accommodation is provided to them, therefore the petitioner of this case is in more advantageous
No,
situation.
you
as-
have already vacated.
Yes, already vacated. Now, I'm
What
not
is your
claiming.
prayer
that-
here?
Lordship, I'm not claiming now any rent amount. I'm only on this line. This case may be disposed of.
No, you have already vacated.
Yes.
And now we was putting up now.
No.
Why you have been shifted?
We have arranged.
Why you have arranged yourself?
Ourselves.
And you are not claiming any error.
No.
HRA.
No. So
So you
on
want
this,
that your case should be considered
on this,
once the project is completed.
yes, on the
That's all.
basis, affidavit they have filed on basis of
No,
this.
that's it. Petitioner of this case can be re-accommodated immediately on the completion of project. Huh?
Yes.
Because you are claiming parity with the similar treatment with the employees of E sector.
Yes,
So
initially,
in that context only, they said you can be re-accommodated after the completion of the project.
yes.
But these people will not, you have to read the whole sentence. Whereas project applicant employees should not have no such advantage. Right?
Yes, Lordship.
We'll record it. Your case will be considered for reaccommodation after the completion of the project. That's all.
Okay, all right.
So you are not pressing your grievance now.
Initial grievance, I'm
No,
not.
no,
press-
it had become infrastructure, literally.
On basis of the affidavit, they filed the department.
Literally, this has been infrastructure. You have vacated the
Yes.
quarter now.
Yes.
Project has started.
In lieu of in lieu of my vacation, my prayer was that initially that I may be also provided I may be also treated equally, which they have been treated to the E-sector group.
That cannot be.
That can, yes, I
They
do
are in
agree, sir.
different
Therefore,
different
on
class
the-
together. They are
the-
different class
Yes, yes.
altogether.
In affidavit,
There is no
again, they have
equality.
said that they are ready to provide the first, as a first privilege to accommodate if this project is completed. Only on that line, my petition may be disposed of. Very limited prayer also.
Urge Mr. Ex-Jati Learned Counsel for the petitioners, and also heard MS Arbasar, Learned State Counsel for all the respondents,
Lordship.
right?
One,
For
two, and
this,
four.
for all the respondents.
Respondent number 3 is represented by Senior Advocate Pritam Tapur, sir.
Lordship, 3 also we will be representing your lordship for
Yeah.
urban housing.
Okay. Housing,
Yes.
all the response.
Yes, yes.
For all the response. This is the second round of litigation by the petitioners, 17 in numbers.
Yes.
Who claims to be the who are the employees of what?
Government of Arunachal Pradesh in various.
Which department? Different
We are
department.
a different.
The Group C and the employees of the government of Arunachal Pradesh seeking a direction to provide similar benefit. No, against the seeking or an accommodation in view of the vacation, in view of the direction to vacate the government quarters to pave way for construction of new project for the government for the accommodation of the government employees at Papu Hill.
Yes, Papu Hill.
Please.
Multi-story flat.
By this petition, the petitioners have prayed for a direction to provide similar benefit to the petitioners as has been provided to the 7 government employees of East sector by an order dated 27/04/2013. Please stop. Where is the first order of this? Let us see writ petition, judgment in writ appeal. Where it is?
Was it writ appeal?
Yes, we'll just mention that.
Page 124, your lordship.
124.
Order.
The petitioners were allotted government quarters at Papu Hill, Naharlagan. And in the meantime, the state government in the Department of Housing issued an order dated 30/06/2020, wherein the PWD Naharlagan division had proposed to construct multi-story flats in place of old quarters at Papu Hill, Naharlagan, where the petitioners were given allotment list of. In order to construct the said project, an alternative accommodation was provided to the petitioners whose quarters, whose government quarters are proposed for demolition for the construction of the flats for the government employees. List of agreed of such proposal, the petitioner approached this court in a writ petition being WPC, by way of writ petition being WPC 254 of 2022. That was dismissed, or what?
Was it, 254?
Hmm?
No, it was not dismissed.
Direction was given.
Yes.
By which order?
It is in page 71 onwards. Page 71 onwards.
This
And
court,
76 is the.
by the order dated, you tell us the order.
Page 71. And,
What is the date of order, sir?
29/7.
29/07/2022. Dispose of the writ petition with the direction to the respondent authorities to consider the case of the petitioner to consider the representation of the petitioner of their grievances for an alternative and suitable place where the petitioners were sought to be accommodated within the period of 2 weeks. No, not within a week. Accommodated, Mr. The petitioner filed a writ appeal, being WPC, WA number 1 of 2023. Mr. The writ appeal was disposed of on 09/06/2023. What I said, the writ appeal was disposed of 23, huh? Mr. While not interfering with the impure order passed by the learned single judge, impure order of the learned single judge, the order of the learned single judge directed the respondent authorities to consider to consider for providing the basic amenities, i.e. electricity and water in alternative accommodation at Lekki Village, Naharlagun. Mr. The order of the division bench dated 09/06/2023 was taken before the Supreme Court by a SLP, special petition by a SLP.
Yes.
Then was just disposed of?
Yes, Lordship. This was from.
When it was disposed of?
Yes, it was.
7/8/2023, Your Lordship.
Where it is?
111.
Page 111.
Saying what?
111.
Hmm?
111.
Saying what?
Yes.
Lordship, this read appeal has been filed by the state of government, state of Arunachal Pradesh, Lordship. State respondent has filed.
SLP was filed by you.
No, so
That's what I'm
appeal,
saying.
read appeal has been filed by the state, Your Lordship.
Acha.
Not the petitioner, Your
Then
Lordship.
you write in place of petitioner, the state of Arunachal Pradesh filed it. Is it so?
Yes, Your Lordship.
Yes.
Okay.
124 page, Your Lordship.
Okay. Mr. The writ petitioner approached the Honorable Supreme Court by a special leave petition being and especially to appeal being SLAC 1238 of 2023, page 111. The SLP was disposed of. When it was 0708,
Yes, Lord.
2023. On the contention of the learned counsel for the parties, learned counsel for the petitioners that they be provided reasonable time to vacate the where this is suit premises in terms of the order dated 30/06/2023 while issuing notice. 30/06 issuing notice. As the notice was issued only for the limited purpose of granting reasonable time to the petitioners to vacate their respective premises so that they will be able to secure suitable accommodation. Mr. thereafter the present petition. Thereafter only you have filed this present petition.
Yes, Lordship.
Yes.
After the disposal of the
Yes.
SLP.
Yes,
Yes.
because after that we came to know that
The petitioners approached this petitioner filed this present petition, present writ petition. With a prayer essentially to provide a similar similar accommodation provided to the employees of E-sector. E-sector,
yes,
E-sector.
Nahalagan.
Naharlagan. Mr. Ex-Kati Learned Counsel for the petitioner. Submits that in view of the affidavit in opposition filed on behalf of the state respondents, to the extent that the petitioners can be re-accommodated immediately on completion of project. What I said, submits, huh? That in we. He had an instruction not to press for the relief prayed for in this present petition. However, a petitioner be re-accommodated on the completion of the project. The flats for employees at Papu Hill, Naharlagan.
Yes,
Right?
yes,
Mr.
Papu Hill, Nahalagan.
So what do you say?
Lordship, the prayer he's seeking in the writ petition is
Something
not the
different.
one he's seeking now, your Lordship. It cannot be.
No,
it all-
he's not pressing that prayer.
I'm asking.
MS R. Basarlan State Council fairly submits that since the petitioners were allotted the government quarters before the in the proposed project, the state will obviously consider re-accommodation
Yes, your Lordship.
in
And we have said this,
in
these two
accordance
groups
with
of
the-
people are totally differently situated.
in accordance with the norms,
Yes.
public guidelines of the government.
They are ready in the affidavit.
Can be,
Can be
see,
recommended,
you
Lordship.
read the sentence.
Lordship.
It is not.
Having considered the submissions of learning council for the parties, I'm of the considered view that there's nothing, submission of the learned council for the parties. I'm of the view that no issue remains to be adjudicated upon in this writ proceedings. Accordingly, writ petition stands closed.
And they have the
However-
option to seek
however-
HRA also, your
however,
Lordship.
Since the petitioner, since the state has stated that the petitioner can be re-accommodated as per the applicable norms and rules, guidelines, it is expected that the state authorities, state government being the state government would consider the case of the petitioner on completion of the project strictly in accordance with the norms and guidelines.
All right.
That's all.
Okay.
Yeah.